Good morning, everybody. Happy Thursday. Welcome to the Courtroom Files Live. We will start our day with Judge McNally.
Good morning, Your Honor.
Your name? Your name?
Richard J. Godfrey.
All right. You haven't been drinking this morning, have you?
I'm sorry?
You haven't been drinking this morning, have you?
No, sir.
So if I give you a PBT right now, it's gonna come up clean?
Yes.
All right, we're gonna just double check that. Have a seat right there. I'm gonna have them give you a PBT, okay?
Put it right here.
First row. Krista Cole. Come on up to the podium. Krista Lee Cole, 25F244368 A and B. Your name?
Krista Lee Cole.
You're charged with driving on a suspended, ma'am, and you also have a second charge of disobey a traffic control device. You have the right to a lawyer. I'll be happy to give you one at public expense if you would like. Would you like a lawyer?
No, thank you.
Okay, so I'll go ahead and arraign you and we'll go from there, all right?
Okay.
It is alleged that on July the 12th of 25, that you were operating a motor vehicle in Breland or Hall in Flat Rock, and that you did disobey a traffic control device, a construction zone sign, count one, that's a 2-point civil infraction. You also have driving on a suspended, which is punishable by up to 500 fines, 93 days jail, costs, or all of those in 2 points. Do you understand that?
Yes, Your Honor.
I'll give you a PBT. Did you sign the advice? Yep. Did you sign the advice of rights?
Yes, Your
Did you
Honor.
read it?
Yes.
Did you understand it?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes, Your Honor.
Okay. You still wish to waive your right to a lawyer?
Yes, Your Honor.
I'm gonna enter a not guilty plea for you. I'm gonna give you a $500 personal bond. You do not have to post any money. I'm gonna send you to the prosecutor. You can talk to the Flat Rock City Attorney. And then either way, you're coming back in front of me. You cannot leave the state without consent. You can't violate a law. You must appear in court as directed. Those are the bond conditions, okay? Do you understand all that?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
Are you employed?
I work 4 days out of the month,
What is that? Doing what?
waitressing.
Okay. All right, so you go out, we'll set you up. Either way, you'll come back in front of me, and if they don't give you what you want, you tell me, I'll give you a lawyer, okay?
Okay. Thank
Good
you.
luck. Harley Quinn Wackosh, file number 25F244090. Your name, ma'am.
Harley, welcome.
You're charged with disturb the peace. You have the right to a lawyer. Be happy to give you one at public expense if you would like one. Would you like one?
No.
I'll go ahead and arraign you on July 11 of 25. It is alleged that you were in the city of Flat Rock, County of Wayne, on Walnut Creek Drive at or near 28521 Walnut Creek Drive in Flat Rock, and that you did disturb the peace. That is a misdemeanor punishable by up to $500 in fines, 90 days jail, costs, or all those. Do you understand that?
Yes, Your Honor.
Did you sign the advice of rights and read and understand it?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, Your Honor.
Okay. Do you still wish to waive your right to a lawyer?
Yes.
I'm gonna enter a not guilty plea, $500 personal bond, okay? You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'm gonna let you go talk to the city attorney, see if you can work something out. If you can, great. If you can't, then, I don't know what.
Where did I go? I'm sorry.
You're gonna go right out in the hallway,
Okay.
and he's going to take you to the city attorney, okay?
Okay, thank you.
You're welcome. Eves, Christina Eves. 20B138279C, 20B138279A. Good morning, ma'am. Your name?
Christina, yes.
All right, so you have the right to a lawyer here today. You owe $5 on one case. And you owe,
Okay, go back.
you owe $175 on the other. Is that what these are up for, Lisa? Show cause hearings on each of these?
Yes, show cause for non-payment.
All right. You have the money?
Not today.
How much do you have today?
Thank you.
Okay. Here's what I'm gonna do. Where do you work at, ma'am?
I work in Belleville, it's a company called Middleton.
I'm gonna waive the balance on, the $5 balance on 2OB138279A. You owe $175 on the other file, you pay $50 now. When can you pay the rest?
3 months,
3 months.
like $50 a month.
How much do you make in your employment?
How much, I make $18 an hour.
How many hours do you work?
40,
You're asking for a lot. Are you married, kids,
yes,
both?
yes,
Does your husband work?
yes.
Why?
We have bills and we're behind right now, we're trying to catch up.
You gotta come talk to me. Right? This has been going on since March of 24 when I sentenced you. You were supposed to pay it that day. I don't know why it wasn't paid that day. I'm gonna assume I addressed it subsequent to that date. You're asking for a lot. I mean, I don't mind working with you, but come on. You pay $20 bi-weekly. I'll do that. When do you get paid next?
Next week,
All right, you pay $20 bi-weekly beginning August the 18th. Do you think you can do that?
yes,
Now, if you don't have the money, you have to come talk to me. Call the court, we'll go on Zoom, okay?
okay,
Or else come in here on or before your due date. So go down and pay the $50 on the one and you're all set. Good luck. People against Godfrey. What'd you find out, John?
I gave you a sticky note there.
Richard J. Godfrey, 25F244515. Okay, so you registered zeros. Good. Your name?
Yes,
Your name?
Richard J. Godfrey.
You're charged with disorderly conduct, public intoxication. You have the right to a lawyer. If you want, I will give you one now, or I will arraign you and let you go talk to the prosecutor. It's your choice. Hey, sir, come here. Come on back in here.
Oh, I'm sorry.
You're talking on the phone, right?
I was answering my attorney trying to walk out.
You got your phone into the ear. Please don't do that. Not in the courtroom. Okay.
Yep.
Thank you. So, you're charged with disorderly person, public intox. It is alleged that on July 23 of 25. So I guess I need to ask you that first question. Do you want a lawyer?
No.
They think that you were publicly intoxicated July 23 of 25 at 3:04 PM on Arsenal near West Huron River Drive in the city of Flat Rock. That is a misdemeanor punishable by up to $500 in fines, 90 days jail, costs, or all those. Do you understand that?
So, what is the fine, $500?
These are the maximum penalties provided by law. That's what I have to tell everybody.
Okay,
I didn't say I was sentencing you to $500 in fines or 90 days jail or costs or all those. I didn't say that. Those are the possible penalties. Okay?
yes, sir,
Do you understand that?
I do.
Did you sign this advice of rights?
Did I what? I'm sorry, I'm hard of hearing.
Okay, that's all right. This advice of rights form, did you read it?
Yes, I did.
Did you understand it?
I do.
Did you sign it? You signed it, right?
This here?
The advice of rights form.
Yes,
If you plead guilty, you'll be giving up all those rights and we're not going to have a trial. Do you understand that?
yes, sir.
Now, do you want a lawyer?
No, I can't afford one.
Well, I told you I'll appoint you one if you want one. I'm gonna enter a not guilty plea for you, first of all.
Okay,
I'm gonna give you a personal bond. You don't have to post any money, okay?
yes, sir.
$500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol, no illegal drugs. You're not to purchase, possess, or consume any one of those. And that's where I'm gonna go from here. If you want a lawyer, I'll give you one. Otherwise, I'm gonna send you to the prosecutor to talk to him.
I don't know what to do, to be honest with you.
It's up to you. If you
I
want,
guess I need a lawyer.
I'll give you a lawyer, have him go talk to the prosecutor, not guilty, pleas entered, okay?
Yes, sir.
All right, good luck. We'll see you back in here either way today. You understand that, right?
Okay.
Yes, sir.
Okay.
Don't go anywhere today until we're done. Okay?
Okay, can I go out to my truck or?
He wants to talk to the prosecutor on
We're gonna give him a defense lawyer.
it. Okay. Just have a seat in the hallway.
And we're gonna set you up with the lawyer that will
Okay.
then talk to the prosecutor, see if they can resolve this. Either way, whether they can or can't, you come up here back in front of me, okay?
Yes, sir.
All right, good luck. Hilario Romero Chavez, 25T718-463. Your name, detective?
Detective Sergeant Mark Driscoll, Trenton Police.
Okay, raise your right hand. You solemnly swear or affirm under
Have a
penalty.
seat in the hallway.
Okay.
Solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes, Your Honor.
Go ahead.
On June 7th, 2025, at approximately 0238 hours, Trenton police officers were dispatched to the area of 3rd Street and Hamwood in the city of Trenton, County of Wayne, for a male asleep behind the driver's seat of the vehicle. Officer Evan McLeod arrived on scene where he observed a white 2011 Ford Fusion bearing Michigan license plate 3 Lincoln Union X-ray 52 facing south in the roadway, stopped partially in the intersection. Officer McLeod observed a male later identified as Hilario Romero Chavez, a Spanish male, date of birth of 2/28 of 1983, in the driver's seat sleeping. Officer McLeod observed the vehicle running with the keys in the ignition and Mr. Romero Chavez's foot on the brake pedal. Officer McLeod and Officer Erica Ducky placed the vehicle in park and awakened Mr. Romero Chavez, where they observed a Modelo beer can in the cup holder and smelled a strong odor of intoxicants emitting from Mr. Romero Chavez. Officer McLeod had Mr. Romero Chavez exit the vehicle where he observed him unsteady on his feet, having bloodshot and glassy eyes, and his speech was slurred. Mr. Romero Chavez provided his Guatemalan identification card. Officer McLeod again could smell a strong odor of intoxicant emitting from him. During Officer McLeod's questioning, Mr. Romero Chavez spoke both English and Spanish. Officer McLeod requested Mr. Romero Chavez to perform SFSTs, to which he replied no. Officer McLeod read Mr. Romero Chavez his PBT rights verbatim from the Trenton Police PBT Advice of Rights form, and Mr. Chavez refused and then was arrested. Officer Blake Rusnick arrived on scene and assisted with the inventory per the Trenton Police impounded vehicle policy. Officer Rusnick located a cellophane bag containing a white powdery substance and white powdery substance on the driver's seat. Upon returning to the Trenton Police Station, Officer Rusnick tested the substance using the multi-drug test kit, which revealed a positive indication for cocaine, and weighed the substance, which revealed 0.1 grams with packaging. Excuse me. Officer McLeod transported Mr. Romero Chavez to the Trenton Police Jail, where he read his chemical test rights verbatim from the DI 177 form, which he refused to provide a breath sample. And Officer McLeod completed the DI 93. Officer McLeod authored a search warrant for Mr. Romero Chavez's blood, which was reviewed by APA Suitman Bothell and authorized by Judge Coleman Hudson. Mr. Romero Chavez was transported to Henry Ford Hospital in Brownstown, where Art and Jennifer Finley utilized the Michigan State Police blood kit, drew 2 1cc vials from Mr. Romero Chavez's right arm. On June 9, 2025, I sent the Michigan State Police blood kit via priority mail to the Michigan State Police Forensic Lab for testing. On June 18, 2025, I received Michigan State Forensic Lab report TX25-7973, authored by forensic scientist Stephanie Grabowski, which revealed Mr. Romero Chavez's blood alcohol was 0.213. Additionally, I checked Mr. Romero Chavez's vehicle and a Michigan driver's record through Link, which revealed he had no insurance and never obtained a license. On August 5th, 2025, I received Michigan Crime Lab report NV25-976-1, which was authored by forensic scientist Daniel Case. The lab report identified the narcotic substance as cocaine.
Based on your sworn testimony, I find the crime possession less than 25 grams of cocaine. Super drunk, OWI, and drive while suspended, revoked, denied were committed. There's probable cause to believe the crime was committed by the defendant. You must have sent this over yesterday. This is dated August the 6th. I changed in the date. We haven't done the signing on record today, August 7th. I'll initial that. I'm signing and dating the complaint and the warrant for the arrest of the defendant. Have a good day. Thank you.
Have a good day.
Paige Bondi, Paige Kathleen Holiday Bondi, 25B715702. Good morning, Detective. Your name?
Good morning, Detective Jeff Claft, Brownstown Township Police Department.
Raise your right hand. Do you solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got?
Yes, sir.
Okay, go ahead.
On February 27th, 2025, at approximately 11:06 p.m., Officer Washburn and Officer Fox were dispatched to 19001 Telegraph Road in Brownstown. That's the BP gas station. They were dispatched for reports of a driver passed out behind the wheel of a burgundy Ford Flex. Upon arrival, Officer Fox observed the burgundy Ford Flex parked next to one of the gas pumps with the driver's side door open. Officer Fox also observed a black male, later identified as Cortez Martin, in the driver's seat slumped over the center console. The front seat passenger of the vehicle was a white female, later identified as defendant Paige Bondi. Officer Fox made contact on the passenger side, while Officer Washburn made contact with Mr. Martin on the driver's side. Officer Fox asked defendant Bondi if they were under the influence of any drugs. Defendant Bondi admitted to consuming mushrooms. Defendant Bondi's speech was mumbled, slurred, slow. Her eyelids were low and appeared heavy, and she was acting very lethargic. Officer Fox looked down near her feet and observed a glass bulb meth pipe with burnt residue inside lying on the floorboard of the car. When asked defendant Bondi if she had any drugs or pipes in the vehicle, she told Officer Fox no. When Officer Fox asked her about the meth pipe by her feet, defendant Bondi tried to place her foot over it and hide it. Officer Fox told defendant Bondi to exit the vehicle. Defendant Bondi exited the vehicle with her purse in hand. When asked if Officer Fox could make sure defendant Bondi didn't have any drugs in her purse, she told Officer Fox yes. During the consent search, Officer Fox located a loaded hypodermic needle with the cap on it. When asked if there was any heroin or methamphetamine inside it, defendant Bondi said both. As Fox continued to look through defendant Bondi's purse, Officer Fox located what appeared to be a folding card holder. Inside, Officer Fox located several pieces of suspected crack cocaine rocks. Officer Washburn placed defendant Bondi in handcuffs and placed her in the rear of the patrol car 1813. Officer Fox continued to look through the contents of the purse. He located a small clear plastic baggie with suspected heroin inside and a small blue metal vial with suspected methamphetamine inside. While searching the vehicle, due to the meth pipe being in plain view, Officer Fox observed a small colored pouch bag sitting on the dashboard directly in front of the passenger seat where defendant Bondi was seated. Upon looking inside the bag, Officer Fox located a second glass bulb meth pipe with burnt residue inside. He also located a glass stem crack pipe with chore boy and burnt residue inside, and a second loaded uncapped hypodermic needle with a red and brown liquid inside. Mr. Martin requested medical attention. Our fire department arrived on scene and transported him. Officer Washburn located a folded up gum wrapper with Mr. Martin's person. When Officer Fox unfolded the wrapper, he observed a tan brown powder substance consistent with heroin. Defendant Bondi was turned over, Mr. Martin was turned over to Brownstown Fire Department for treatment. Defendant Bondi was arrested and brought back to the Brownstown Police Department. Evidence that was collected was the suspected crack cocaine, methamphetamine. A field test was completed with positive indication. The loaded syringes were not field tested due to the hazard of testing them. The heroin recovered was also not tested. On 4/21/25, Detective Attard conveyed all controlled substances to the Michigan State Detroit lab for further testing. On May 1st, 2025, Lab results from the Michigan State Lab were provided. Recovered from Mr. Martin's person, it was identified as 0.3982 grams of fentanyl. Recovered from defendant Bondi's purse, it was identified as 1.0734 grams of cocaine. And recovered from defendant Bondi's purse, it was identified as 0.2747 grams of methamphetamine. Defendant Bondi shows prior convictions on February 7, 2018, assaulting, resisting, obstructing a police officer, pled guilty on 9/6/2016, obstructing by disguise, pled guilty 10/4/2016, malicious destruction of property, and 9/24.
They did not include a habitual offender notice.
Oh,
so you
okay.
don't
I'm
think
sorry,
you-
Your Honor.
those, but I'll go ahead and authorize. I'll note that you signed this yesterday. I'm changing the date of the signing on record to today, and I'm initialing it. There's probable cause to believe the crimes of possession of less than 25 grams of cocaine, possession of meth, and possession of heroin / fentanyl were committed. There's probable cause to believe those crimes were committed by the defendant. I'm signing and dating both the complaint and the warrant for the arrest of the defendant. Thanks a lot. Have a good day.
You too, sir. Thank you.
Curtis Amati. Call in Beth.
So good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Thursday. Just wanted to say hi. Let's get back to Judge.
R513926A.
Good morning, Judge. May I get your behalf of Mr. Hamadi? Mr. Hamadi, state your name for the record.
So Ms. Wilds checked into this, and I'm going to let her explain this. This was all over the other convictions out of Arizona and Florida, and at least it appears as though he had the conviction out of Arizona from '99, the conviction for OWI in February of 12 out of Florida. Excuse me, but the other one from 2012 out of Arizona, we could not verify. Your name?
Elizabeth West.
So can you repeat that? Is that true? He's got 3 convictions on his precinct.
I'm sorry, Judge. It's the 99 conviction that would be substantiated.
Well, he's got 3 on here, right? He's
Right,
got,
Judge. It's the one from 1999 that we had an issue with. That's why it was adjourned twice already on this to verify that. And then also, Mr. Hamadi's, there is no conviction out of Florida as well, Judge.
wait a minute. Why don't you tell me what you determined?
Yes, Your Honor. You asked me to go ahead and kind of extensively look at the record. And because of the sex registration, Florida is reporting the Arizona offenses. So he is correct. So what's occurring is on the Florida driving record, it is showing a conviction for drinking and driving, and it's also showing on the Arizona CCH. It is the same offense. That is out of Arizona, and that is the 2012. On his Michigan driving record, it is showing a conviction for the 1999 OUIF, but what catches your eye is the fact that the arrest date and the conviction date are both from, I believe it's March 19th, 1999, but it is indicating that that conviction was by default, the same as the 2012 that Mr. Hamadi admits and is also on his CCH. That also reports back at the Michigan driving record by default. So the question at hand, is the 1999 a conviction or not? I ran his Arizona driving record, I ran his Arizona CCH along with Florida, along with Michigan. I can't find it on any criminal history. I can only find it on the Michigan driving record entered as a default with, again, the same arrest and conviction date.
So in your view, how many prior convictions does he have? It's not the 99 one. He doesn't have that.
Correct. I'm seeing the 2012 out of Arizona, and then I believe this would end up being his second offense.
So not that there are 2 in 2012, one out of Arizona, one out of Florida. You're saying
Those are the same.
right.
Yeah.
So he's got only 1 prior drunk driving conviction as far as you can tell, and that is in June of 12, correct?
That is correct, Your Honor.
Let me
That's the only
just-
one I can confirm.
Okay. Okay. Give me 1 second, please.
Sir, you gotta take your hat off.
All right, now we had a problem with the prints, by the way. I don't know what happened. This is what I read. Per MSP, defendant needs to be printed again. Called defendant and advised to get printed at Gibraltar before sentencing. Did you do that?
Yes, Your Honor.
He did, Judge. I verified before today.
All right, so do you have any questions of Ms. Wiles before I let her go? I'm gonna count this as him having one prior OWI or impaired conviction, and that is the 2012 OWI, it appears, but not the 99 and not the other one.
Correct, or neither is the one in Florida, Judge, that one was just.
I understand, so we have one prior OWI conviction and that's it.
Correct,
Besides these others that are not drunk drivings.
correct.
So, anything else?
Nothing further, Your Honor.
You can go ahead and go, thank you very much.
Thank you, Your Honor.
Are there any material additions? So with that, and I'm gonna strike it just for the record, I'm gonna cross out the OWI, and I'll say excluded, AM. And then, so I'm modifying the report in that aspect, and then also the the February of 12 case excluded, and I'll initial that. What, is everything else in this report accurate?
Everything else, Judge, appears to be accurate, correct.
Is there anything you'd like to say on his behalf?
Just that Mr. Hamadi is 51 years old right now, and he owns his own home renovation company. He has a 13-year-old child who lives with him, and he just recently reconciled with his wife. They've been separated for a number of years. So he's in the process of getting his life together. If you notice the dates on a lot of those convictions, Judge, those were prior from Mr. Hamadi's past. Let's say when he was younger and not as smart as he is today. And I would let the court know that, you know, he's taken responsibility for everything that he's done. He's tried to make amends. Obviously, he's not run away from his problems. He's faced his consequences, got through it, and is trying to move on, Judge. And we'd ask the court to take that into consideration, as well as the fact that this will be the third time that we will be before the sentencing on this case, Judge.
Anything you'd like to say?
Your Honor, just that I know that I've made a lot of mistakes, and I'm too old to be doing this, and I just want to do the right thing and move forward and take care of my family and be a positive member of the community. And I apologize to the city of Rockwood and to this court. And I just want to move forward as best way as I can, Your Honor.
Additionally, Judge, if I may, Mr. Hamadi is also taking initiative to start the Victims Impact Panel program. So he's making good faith, positive efforts towards getting a lot of the stuff that he needs completed.
You're still getting yourself into trouble. I mean,
There's no reason that I should have been driving.
yeah, but it's not just that. You had, in 21, even, you know, that's 3.5, 4 years ago, but you had a criminal trespass in Florida. You had a larceny in the second degree out of Florida. I mean, it's time to grow up.
I understand, Your Honor, and the trespassing was involving my daughter who I was living with me, and I just promise you that I didn't intend, you know, for any of that stuff to happen. I made a lot of bad choices, and I need to make better ones, and I apologize to this court.
I believe, Judge, also the larceny charge was the fact that there was an issue between him and his daughter. He took the phone away from her. And he ended up getting charged with larceny. 18
months probation. You cannot leave the state without the consent of the court. I'm not sure how you're working and still collecting government assistance. You're saying you're collecting bridge card money.
Because my work has been pretty non-existent. I haven't worked too much in the past couple months.
18 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. If you consume food or other items that contains those substances, that will be deemed a violation. Submit to chemical testing PBTs and ETGs as follows. Bi-weekly for 3 months. If you're clean, I'll make it monthly for the duration of probation. Attend AA, NA twice a week until you're in outpatient treatment. My court officer's going to give you a form. You have to go in person. Every time you go, you have to have that form signed. Every time you come to probation or to court, you have to bring that form with you. You have to go twice a week until you're in outpatient treatment. Once you get in outpatient treatment, you no longer have to attend AA or NA. Attend the Victims Impact Panel, which is one night put on by Mothers Against Drunk Drivers. You're to serve, he spent 1 night in jail on this, right, counsel?
I believe so, Judge.
4 days jail credit, 1, serve 3. I'll let you serve the other 3 on the court work program. There's a $35 a day charge for that for a total of $105. Pay $300 in fines, $250 costs, $75 victim's rights fee, $50 justice assessment, $675 in fines and costs, including the mandatory fees. You have $60 screening fee for $735. You have probation fees of $360. Bring your total to $1,095. They're $20 a month, and then you have cost of recovery of $225 for a total of $1,320 plus court work program fees. Your total should be $1,425. Would you double check that, man, please? If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal if you cannot afford one. Do you understand that?
Yes, Your Honor.
Do you have all of this to pay? How much does he have, Mr. Gate?
Judge, he needs a payment plan.
Does he have anything today?
I don't believe so, Judge.
I don't, Your Honor.
How much can you pay per week?
Can I do $50 or
A week?
probably swing that?
You need to get back to work.
I do.
$50 weekly, beginning August the 25th. If you ever need more time, you call the court. We'll go on Zoom on or before the due date. Or you can come in and talk to me on or before the due date, 8:30. I'll be more than happy to give you an extension. Please don't ignore me, okay?
Yes, Your Honor.
You'll meet with probation before you leave. Any questions?
No, Your Honor, only that I heard you mention no marijuana. I am a medical card holder. That was the only thing.
Yes, you do have a medical marijuana card. I won't violate you because the law doesn't, well, it makes that inappropriate if you test positive, so long as you possess and provide proof to probation of a valid medical marijuana card, okay?
Yes, Your Honor.
Good luck, thank you. Stay out of, you gotta get your life in order, though. Good luck. Krista, Lee.
All right, let's change it up. We'll go to Texas. Judge Stevens is off and running.
519, you have been indicted recently by the Jefferson County Grand Jury for the second-degree felony of assault on a peace officer. And that carries with it up to 20 years in prison. So it's obviously something that has to be taken most seriously. And are you, were you retained, Don, or are you?
No.
Do you have a job or something? Are you able to hire a lawyer?
So
You're not, why not? You don't have an income?
I'm going to school right now.
Doing what, sir?
Well, I'm going to say for the pipe service.
Okay, what was the last employment you had? Because you're 38 years old? Yeah. When did you work last? When did you have an income last?
Before I went to jail, that's how I lost the job.
What was the job?
I was a
Pipe
porter.
fitter?
No, I was a porter, working at an apartment complex.
Okay, so you're trying to get your pipe fitters.
Yes, sir.
Okay. Man, I think they felony offenses don't help. to get your, now I know, I used to represent the pipe fitters when I was in private practice. And they're all a good group of people and they generally don't commit crimes. So you need to fix this with, your attorney here. Do you have any prior convictions? You do? What are they?
He's got a delivery of a controlled substance in 2015,
What was the disposition on that?
7 years prison.
There's not an enhancement here.
No, sir, not yet.
No.
And evidently intake listed, and then there's a prior possession that he got 6 months state jail.
Okay, according to the prosecution here, you have a prior conviction, which if what is generally done is prior convictions are researched generally a lot of times after indictments, when they discover that there's a prior felony conviction, it can be added to the indictment, which means this second degree felony can turn into a first degree felony if you have a prior felony conviction. Then you're looking at up to life in prison. And that's what I see coming down the pipe, because that's what's generally done, is they add prior felony convictions if it's allowable. And here you committed this offense after your other felony was after you were convicted, and that was final. So you're probably going to be looking at additional exposure. So and when that happens, if they re-indict and it's increased, your bond's going to be increased too. You're going to have to deal with that. So you and Mr. Dusler here probably ought to figure out how you can do some damage control. And he's a sharp guy. He knows how to help people. So until that time, though, we're going to reset it for 3 weeks for review of where the status is on this, because there's nothing we can really do until that. If they're going to re-indict, that has to be done, or it will interrupt the proceedings. And you need to know where you stand on where they're headed. And they just they have a right to add other convictions if they can enhance the punishment, and that's what happens. Nothing good here, but you need to know where you stand so you can deal with it. All right, I'm resetting 3 weeks, and I would stay in touch with your attorney here.
Okay. Reset and wait for me also.
Sharon Lee. Sharon Lee, please. I have 2 cases on this lane. What are we doing here?
He is in the process of hiring Lane Webber, asking for 4-week resetting to do so.
Is that right?
Sir,
Is that right? You're
In the
hiring?
process of hiring Lane.
Wayne Walker,
When is that going to be done?
I spoke with him yesterday.
I know but speaking with them, generally you have to,
Put in 2 weeks. Oh.
yeah, make some payment and
Yes, sir.
to hire them. Do you understand the seriousness here?
Yes, sir, I do.
Okay. Just not 1, but 2 first-degree felony indictments. You were looking at up to life imprisonment on each case.
Yes.
Each case. They're all serious in this one.
Yes.
First-degree felonies or murder, capital murders, capital cases are the most serious. Let me ask you, what was the bonds? What were the bonds in these 2 cases?
$8,000.
You paid 80,000, you paid 80,000 on each case?
No, sir, 4 and 4.
And why haven't you hired a lawyer if you can pay $80,000 for a bond?
Pay $8,000.
Who did?
Bondsman. Yes, sir.
No, bonds, no. What you paid somebody, they don't just,
And no.
you You know, maybe when I speak, you should be quiet because she can't take both of us speaking. And when I speak, if you'd be so kind not to rudely interrupt. Because what I say is very important for you. I try not to waste words. You posted an $80,000 bond. Okay. It wasn't 80,000, but it was 80,000 in cash, but you had to hire a bondsman and I know what it costs them. If you can come up with that kind of capital, why are the taxpayers paying for your lawyer here? That's my question to you. You need to pay for your mess that you've gotten yourself into. The taxpayers don't think they ought to pay your way. You haven't hired him, right? No, he's an appointed lawyer. The taxpayers are paying for him. You were able to post an $80,000 bond. I want you to go hire your own lawyer. You've got assets somehow. Don't look at me like I can't believe it's butter. I mean, what's it? You got this physical look about you.
I didn't pay.
He's representing you.
I've never spoke to him.
You haven't? Well, go
today.
hire your own lawyer.
She's working on it.
Yes.
We met today. She advised me
Okay,
she's hiring.
he's the public defender. He is appointed by the people. You're supposed to have your own lawyer, you know, and that's what most people have up here. Maybe you didn't know that, but the people aren't going to pay for the lawyers when you have the ability to post $80,000 bond. That's just math. You got to, there's no move. When we make a mistake, you got to fix it on your own. And sometimes it costs.
Yes, sir.
But you need to go hire your own lawyer if you can pay that. And Don Dusler is not going to continue to be the appointed lawyer by the people. He's paid by the people. And but he's got valuable advice while you've got him here. All right. You got, when are you going to hire Mr. Walker?
I'll speak with him when I.
No, when are you going to hire him?
3 weeks.
Yeah.
2 3 weeks.
You
I
say
think we're
3,
going to pay. Yes, sir.
3 weeks?
Yes, sir.
Okay. So I'm going to reset this in 4 weeks.
Yes, sir.
And you're going to get a resetting. Give it to him or whoever you hire
Yes, sir.
so that they know when the next event is, so that they can properly, there's a way of formality getting into the system to represent you. And you want, they need to know that. So give that to them. We're going to give this to you. Get a resetting.
Yes.
4 weeks.
Just repeat.
I like it out.
Justin Moore.
I was told this morning that that his boss was notified your clerk that he's in the hospital. She just told me.
Well, like, what's he doing?
He was in the.
Is it custodian work?
I don't know. Your coordinator told me this morning.
Okay,
She was just notified by the bondsman.
okay. We're going to call Justin Kyle Moore. Justin Kyle Moore, 3 cases, 23 CR 1784, 23 CR 2027, 23 CR 2028. Justin Kyle Moore. There is no answer in the courtroom. I'm asking the bailiff to call into the hall, please, for Justin Kyle Moore.
Justin, Kyle, or.
All places too.
No response, Your Honor.
There's no response to the name being called here in the hall, in the courtroom, and no response to the name being called into the hall. Defendant has failed to appear. What are his bonds? We're going to make tentative findings and verify that he is unable to be here because he might be in the hospital. And if that's true, then that purges him. But
I understand. So on 1784, it's $5,000. On 2027, it's $7,000. Now 2028, it's $15,000.
okay, each of those bonds are doubled for failure to appear, and these are tentative findings. And if he's unable to be here, of course, for hospitalization reasons, that purges him. And the warrant will be issued for us, big arrest, but we will hold those until we know for sure. You don't know why he's in the hospital? Right?
No, I mean, Ellie just told me that she's got notice from bondsman.
Mm-hmm. Okay.
All right, let's switch it up again. We'll go to Miami-Dade. Judge Grumpy Pants is back.
and calling medical offices sometimes, but you really have to watch your words, because look what happened. And I see he doesn't have any prior arrests.
He does have some stuff out of Georgia.
All right, so, all right, I wish you a good day. I'm releasing you to go to the pretrial services will supervise you upon your release, and please stay away from this medical center, the Sanitas Medical Center. Do you understand, sir?
I do, ma'am. Thank you. Thank you so much, Judge.
You have a good day, sir.
You too.
Next case is Antonio. I'm sorry, who do you want me to call next? Mr. Adrian Brochero? Sorry, you said he's here? Good morning, Mr. Brochero. I don't know if there's victims here or who or what. You got arrested for false imprisonment, battery, and battery. And I will appoint the public defender's office for you. So let me promote. Is that the victim? I don't know. I don't think so. Let's promote this person.
I think
See
it's a
what.
family member.
All right, good morning. Who are you, please, on Zoom?
So his family here at the moment, his sisters and his parents, and I just wanted to
I don't know
let
what
you
you
know.
just said. 1 second. Who are you?
Sister.
His sister. Good morning.
Good morning. I just wanted to let you
Wait,
know,
wait,
Your
wait.
Honor.
What is your name?
My name is Paula.
Okay.
I
What
know
is your-
that his other sister is here too, and both of our parents. The defendant does have, Adrian has somewhere to go if he is let go on bond, and we will ensure that he will do everything as needed and followed and attend his court dates and do everything as needed. He does have a job, he goes to school, he is a college student. So he does have, community ties at the moment, and we just would appreciate anything that you can grant him, Judge.
Okay. I'm just reviewing the arrest affidavit for probable cause.
The alleged victim is here, Judge.
Oh, okay. They want to promote them?
Promoting now. She's joined.
Good morning, Judge.
Good morning. Can you put your video on, please?
Yes,
You have to accept the ask to start video. Good morning. Would you like to raise your right hand to be sworn, please? The other hand. Do you swear or affirm the testimony you are going to give in this proceeding will be the truth? If so, state I do.
yes, I do.
Okay, thank you. You can put your hand down. Please tell me your name.
Valeria Villan.
Valerie Avalon?
Yes.
All right, are you afraid of Adrian Brochero?
Yes, I am.
Okay, and you want a stay away order for a cooling off period, I take it?
Yes, I would.
Thank you. Yes, ma'am.
So, ma'am, do you live in Florida?
Yes, correct.
Okay, do you have another place to stay away from him?
Yes, I do.
Or does he have somewhere else he's gonna go to? He's gonna go with his family and you're gonna stay where you're at?
Yes, I'm sure he'll go with his family and I'll find some.
Were you guys living together?
No, we were not.
Have you ever lived together?
No, we have not.
Okay.
I'm just reviewing the arrest affidavit.
And obviously, while the family's here, the stay away order is gonna prohibit third-party contact, so they're not allowed to contact you on his behalf, okay, ma'am?
Okay. My biggest fear right now isn't my own life. It's my family's life. And I would like the threats were not only made to me, but my family as well. I don't feel like I am the only one in danger.
Was this the first time this ever happened?
No, it's not. This is the second time that it has occurred where my family has had to intervene with Adrian's behavior towards me.
I'm just reviewing this.
Ma'am, and you're done, right? So she shouldn't contact you at all.
Okay.
It's more of a question, but
That's okay. I understand.
Okay, I'm just trying to see what he did to Mr. Rodolfo Kirkout, and I'm trying to figure out why he gave me 2 stay away orders for the same person with the same name.
I think it was a mistake, Judge.
It's working too hard. Okay.
Yeah.
Okay, I got it. There's probable cause for the 2 counts of battery and false imprisonment. Got it. All right. So, Mr. Brochero, you are ordered to stay away from the alleged victims, Valerie Avillan, as well as Rodolfo Kirkout. No contact with those alleged victims, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victims through social media or other electronic means. And you must stay at least 500 feet away from the victims, their home, school, and place of employment at all times. Do you understand the stay away order, sir?
Yes, I do.
Okay, thank you. So I don't know if the family, if they're able to afford a bond. I understand he's 18. He'll soon be 19. Do you want me to do pretrial? What is this family asking for in terms of his release? Miss
They could
Paula,
ask for us or a bond.
are you going to be posting a bond for him? Can the family afford a bond? Miss Paula's not responding.
Yep.
Is the family going to contact a bondsman? Are you able to afford a bond? I don't know. She's not responding.
Judge, he's okay with with pretrial services, Judge.
And the state's requesting either house arrest or a monetary bond.
He has no priors.
He does work, he goes to college, Judge. He'll
All
stay.
right. Miss Alvian, any contact by him or his family, you need to contact the police, all right? You understand?
I'm sorry.
No. If he tries to contact you, you contact the police, he'll get rearrested and be locked up in jail. All right, you don't have to be afraid of him because this court's ordering him to stay away from you. Pretrial alternate bond, count 1, false imprisonment is $2,500. Count 2, battery is $1,000, and count 3, battery is $1,000. All right. Thank you for coming in, ma'am. Good luck to you, sir. Good luck to you, ma'am.
I'm so sorry.
Oh boy, I'm gonna mute her out and let's mute everybody out. Okay.
That was an interesting transition right there between contestants. Don't often hear the whining and the crying in the background. That was unique. Let's take a moment and talk about the sponsor for today's program, Aura. So, you guys have been hearing me talk for a good week and a half, 2 weeks now about Aura, and I wanted to let you know that what I've had to say about them isn't just my thoughts on the matter. I wanted to share something with you. Again, Aura is a one-stop shop solution when it comes to protecting yourself and protecting your privacy and your data online. And I think it's a perfect fit for this audience, which is why I was happy when they asked if they could partner with the channel. But we have a regular viewer of the channel who chose to sign up for Aura, and I'll leave their name out of it, but they reached out to me yesterday and said that they were setting it up. And 11 minutes later, they reached out again. And they said, and I quote, "It's crazy. It's finding breaches from 2016 and with a password that I regularly use. The blank? I got it doing data removal now. So I tell you that you get a 2-week free trial here when you sign up for Aura using our link, and that'll be more than enough time for you to see what it will actually do for you. But this person found out within minutes that they had a problem. And Aura goes about finding these problems and protecting you in multiple different ways. There is identity protection, transaction monitoring, spam and junk mail removal. There's an antivirus. There's a VPN, scam call protection. Honestly, the spam and the scam calls are the biggest thing I've personally benefited from. I've gone from having 10 or 12 calls a day to virtually nothing, so that makes a huge difference. There is a password locker. There's all sorts of things that Aura can do for you, and it does it all in one program. So instead of having a whole bunch of things, you do it all in one piece. And again, as I mentioned a few minutes ago or a few seconds ago, I've gotten you a 14-day free trial to try out Aura to see what it will do. Go to aura.com/TCF. It's more than enough time. The sign up is simple. And very quickly, as this other viewer demonstrated, you'll find out exactly what it will do for you. You will see where the holes are when it comes to your data online, and it will immediately start to take action, and you'll see the difference. Again, it's aura.com/TCF. It's a 14-day free trial. You have nothing to lose and everything to gain, so give it a go. Aura.com/TCF. You can scan the QR code on the screen, or there's a link down in the description. Let's go back to Judge Glazer for a few.
¿Entiende, señor?
Sí.
All
Yes.
right. How long have you lived here in Miami for?
¿Cuánto tiempo lleva viviendo aquí en Miami?
Tengo 17 años.
17 years.
All right. State, are you okay if I set his bonds at $5,000 or $3,500? He has no priors.
Right, that's fine, but he can't go back to that location.
¿Le
30
parece bien? Ujú. Puede programar su fianza en 3,500. Está bien, dice la fiscal, pero no puede regresar a ese lugar.
$3,500 bonds. Have a good day, sir.
3,500 de fianza. Que tenga buen día, señor.
I think there's also a detective here for PCH, page 18, Andrews. Whenever the
Yes.
clerk in corrections is ready, let me know.
I'm sorry, what did you say?
It's Derek Andrews, page 18 for PCH.
Do you have it?
He's coming up, he's a violent felony offender of special concern. He's on probation on F232387A.
All right, thank you. Thank you very much. So he's on page 18. He's also on probation hold for F232387A. It says PCH. There's nothing here. Good morning, deputy. Raise your right hand to be sworn, please.
Morning.
Good morning. Do you swear or affirm the testimony you're going to give in this proceeding will be the truth? If so, state I do.
I do.
Thank you. All right. So we're here because you, Mr. Andrews was arrested. First of all, what is your name and police department? I'm sorry.
Rene Mateo, Miami-Dade Sheriff's Office.
Go ahead, state.
All right, so you charged occupied. I think the cars were unoccupied, correct?
Yes, that was a clerical error. It's supposed to be unoccupied.
Okay, and the damage, was there damage to every car?
There was, out of the 5, 1 of them was left unlocked. 4 of them were smashed windows.
Do you know the amount of damage for the 4 cars that were damaged?
Each window's about $299.
Okay. Were they all the same window within each car?
No.
Okay, that's fine. How do you know he's the one who broke into these cars? What's the evidence?
He was identified from a video by the probation officer.
So were there multiple He did it multiple times?
Yes, I have him on several different cases, including this one would be 5 cases total.
Was he on video in all 5 of those cases?
His vehicle was, yes.
Okay. His vehicle, but could you see him in the video?
Not on all of them, no.
On some of them?
Yes.
How many?
2 or 3 cases.
Okay, and was it the same MO and all?
Same MO, yes.
Okay, anything else you think the judge should know?
He has on the videos, he has the tailgate down. He was also stopped for a traffic infraction by a uniformed patrol officer, and he was the sole occupant and driver of the vehicle. My sergeant and my partner, Detective Severio, also saw him as he was driving the vehicle on one of the days with the tailgate opened, where he drove into a bank and then drove out of the bank without committing a crime.
Explain to me the significance of the tailgate being open.
The tailgate being open is a way for him to conceal his tag from being read by any license plate reader or by video cameras at any location.
Got it. All right.
The tailgate also has an automatic feature where he's able to open the tailgate from within inside the vehicle, whether it's through the remote control of his alarm or passive vehicle alarm, or a button within inside the car where he does not need to exit the vehicle to open the tailgate.
Okay, thanks so much, Detective.
Ms. Corey, any questions?
Yes, Deputy, what day were these incidents?
These incidents, first one was Monday, June 16,
June 15 or 16?
16.
And where was that located?
That incident occurred at 17211 Northwest 52 Place.
And on that one, what time of day was that?
That time was approximately 12:06 p.m. The incident occurred between the incident on this occurred between 10:30 and 10:45 in the morning.
So why did you say 12:06?
Because that's the time it was reported.
Reported, okay. And what type of vehicle?
The victim's vehicle was a Chevy Traverse.
So Judge, I'm sorry to interrupt Ms. Corey, but I do have a copy of the search warrant, which has the specifics. I don't know if the detective's okay with me sending it over to Ms. Corey. Detective, is it
Yeah,
okay?
I'm okay with that.
Okay. And I can forward it to the court as well, so it's got all the specifics.
That's
don't need
that's
it,
one of the
just-
many search warrants for this case.
You can just file it with, yeah, I don't need it.
Okay.
And was there video of
Yes.
Any incident from June 16th?
From June 16, yes, there is video.
And was Mr. Andrews identified?
Not in that case, no. But the truck is clearly seen at the bank and at the victim's at the incident location where the vehicle was burglarized.
The judge, the search warrant goes into detail about every specific date.
Okay.
I did
We-
send it. to the
There's
court.
also a case within the Opelika jurisdiction where he is observed on the video of Opelika as the driver of the vehicle, exiting the vehicle and making entry to another victim. That's not my case, but that has been done through information sharing with other agencies, and he's also seen with the tailgate of the vehicle down on that day.
So just to be clear, on the June 16th case, Mr. Andrews has never been identified as the person that burglarized the Chevy Traverse. June
Not
6th.
on the June 16th day, but his vehicle was in that area where the incident occurred. And at the bank where the victim came out of.
On June 16th?
On June 16, yes.
Okay. And then the next one after June 16th, what date was that?
The next one was Monday, June 23rd.
And
All this information is in that search warrant if you
Well, if
like
it
to
was
review it.
provided to, I know, but then we can either pass it and I can read it, whatever the court would like to do. But
I
I don't mind.
PC, I understand that he wasn't identified in some of the incidents, but his vehicle was identified. There's the tailgate that goes down, which is very distinctive, and there's the same MO in all of these cases. He's on probation, so the state's requesting that the court find probable cause. Set a
Judge,
bond.
I would at least like to have an opportunity to review the probable cause affidavit for
So-
the search. If
Did you receive it? Go look at it right now, or I can reset it for the afternoon. I don't
They're
think I
signed
need
by
to get
judges.
back.
Like the
that's
PC's
fine,
good.
Judge. If you want to reset it for the afternoon, it'll give me a chance to read it. It's 9 pages long.
Or
And
I
I
can
don't
just,
think I need the officer to come back. Thank you so much for coming in.
Well, I'm sorry, you'll contact me to come back?
I don't think you need to come back. I think the affidavit in support of the search warrant should be sufficient.
Thank you so much. Have a great day.
all right, so you want me to reset it in the afternoon for you to review the search warrant?
Yes, yes, please.
Okay. I think there's enough now for probable cause, but obviously you have a right to respond. I'm making a preliminary finding of probable cause and resetting it for the afternoon for Ms. Corey to review the search warrant. Okay, next is Burry Kelsey, page 7. Morning, sir. You were arrested for possession of a controlled substance and also possession of drug paraphernalia. I will appoint the public defender's office for you. Is this an added charge or no?
He's got a whole bunch of misdemeanors. I think he's.
Oh, that's why. I gotta set a bond then. I can't give him tap. $1,000 count 1, 500 count 2. Have a good day, sir.
Did you said yes to tap or no?
No, I'm not. It's all these open cases. I'm giving him a bond. 1,000 count 1, 500 count 2.
There's 5 misdemeanors.
Yes, 5 open misdemeanors.
Judge, it's a residue charge?
I lowered it. You want 1,000 count 1? I'll do $1 count 2. How's that? 1,000 count 1, $1 count 2, but he has 5 open misdemeanors. Next is Rolando Rodriguez Caballero.
Let's bounce back over to Texas and continue with Judge Stevens.
On a peace officer, which carries with it up to 20 years in prison if convicted. Very serious. And Ms. McNally is representing you at this time. What do you want to do today?
Judge, I need 4 weeks.
You need 4 weeks?
To go over the media and relay the law.
Telling me most questions.
Work with her. She's a very nice lady and very confident, and she'll help you. She's your lifeline in this. Are you still at 4150? Is that your address?
4155.
Okay. I had 4150, but it's 4155.
Yes.
And the number I got 123.
Yes.
I guess they just did this wrong. Okay, we corrected this. And please get a resetting. Thank you. Jesse.
Ma'am,
Right here, that's a Jesse Fan.
Oh, I did that.
Fan. On.
Raise your right hand. Where or from your face.
Okay, 25 CR 334 is now called. Jesse, is it Kuyat? And your last name is pronounced Fan? Oh, all right. Ciao.
Hello.
And Miss McNally, very good lawyer, representing you. You were charged with the state jail felony of theft. Hello. Oh, boy. Yeah, second page is, and third page go on. You're charged with theft. And if you have two or more prior theft convictions of a felony, or above a Class C misdemeanor out of courts in Texas for thefts. If you have two or more, then if you steal a pack of gum, it's a state jail felony. You're looking at up to 2 years just for that. So it's not a wise thing to commit thefts. You were convicted in 2014 here before me. You remember me?
I remember just sir.
Okay.
My very first text, you sent it to me like 18 months.
18 months?
I didn't respond to it. You asked me a question. I was young at the time, and I didn't know how to answer it.
Well,
And like
that was, it looks, well, I'm kind of disappointed because
I just been drugs all my life, man. I'm afraid of something about that other woman.
you committed 12 thefts in courts at law or district courts since you were in my court. 12. And then now we've got another one here. So it's a state jail felony. So you were looking at up to 2 years in state jail. So today,
Judge, I am in conversation with Ms. Staub, but that has obviously ceased this week since she's out at conference. I need to talk to her about an offer and see what that looks like.
so you talked to her and she immediately left town.
Yeah, she just ran out on me.
I would like to have been present at that conversation.
I'm just joking. Ms. Staub is great.
How much time?
4 weeks.
4 weeks, okay. Get a resetting is. Jesse, don't steal. Don't steal.
Yes, sir.
Be honest.
I'll wake up thinking about doing it, just the drugs.
That's not an excuse. Don't use drugs.
Yeah, I'm not.
Okay, fix this.
Highlighted that for me.
Otis Pollard.
Fill out the
Otis
thing.
Pollard.
Even if this is zero, we have no income and no expenses, you still have to zero, okay? That you could. What was tonight?
The way this is.
Did we have an add-on today on this initial document?
Yes, sir, that's.
Okay.
That's the defendant from Monday that had to get a GPS device and we just needed to confirm that he
Okay.
has a GPS device and sets in.
Okay.
restrictions.
All right. Otis Pollard,
Yes, sir.
2 cases here, 25 CR 138 and 139.
It's for our firm, if your information is not in the
Oh, boy, we got some priors here. On 138, you were charged with the 3rd-degree felony of unlawful possession of a firearm by a felon. So it looks like you have a burglary of a habitation according to this conviction out of the court next door, 252nd in 2001. Thereafter, that was final. This states you were convicted in that court again in 2011 for burglary of a habitation. After that became final, you were convicted in that court once again for assault on a public servant, 3 priors This means if all of this was true and you were found guilty, you're looking at no less than 25 years in prison, up to life in prison. Do you understand?
Yes.
Habitual felon. Now we go to 25 CR 139. You were charged with a state jail felony here. And the two priors make it a state jail. Two prior thefts, misdemeanors. Again, like I was telling somebody before, if you steal a pack of gum from now on, it's a felony. And you got this is alleging in sequence burglary of habitation and the second degree felony, another burglary of habitation, 2001 and 2011 out of the courts next door. So this felony, state jail felony, can be enhanced to second degree felony punishment. So this is not good. You're looking at life in prison, up to life imprisonment on one case and up to 20 years in prison on the other. So you understand?
Yes, sir.
Okay. You've fallen in a minefield. You got to tread lightly and responsibly to navigate through this mess. She's your lifeline. What are we going to do today?
Judge, I need 4 weeks. I'm not receiving academic case and I also making that we want to review.
Okay. Get a resetting. 4 weeks.
Thanks. So,
Might I have Matthew Graham, please? Matthew Graham, thank you. 24 CR 425.
Just. You must be a drink. Right here. Let me get this. And then I'll. Okay. It's on. I like it.
And Mr. Graham, how you doing on, it was a GPS we needed, right?
Correct.
You got that?
Yes, sir.
Okay. How's that working for you?
So it's existing. It's.
Yes. So it's on your ankle?
Correct.
You got to be careful in the tub.
And the typing out.
In the tub. What did they tell you? Did they tell you how to deal with it?
Only waterproof.
It is waterproof. That one is good. They're doing, that's good. They're modernizing things. A lot of people had to kind of wrap their leg when they took a bath or a shower.
The GPS company wants to know what the restrictions are, if he has a curfew, where I guess he's allowed to go, that kind of thing. So we can send that for the company so they can have that in place.
Wait, who is representing you?
There's Tuesday.
That's that name.
And we had to replace Mr. Dukler.
Yeah.
Is it Megan?
Mr.
With
West.
the conflict, so we have now appointed Mr. West, who's on vacation, but we had already had this set.
Okay. Okay. One of the conditions of bond is you've got to, until we can sort this out here, Mr. Grant, you're going to be on what we call house arrest. You got to stay at home except for work purposes. And you are allowed out for purposes of work, purposes of getting food, purposes of medical. And that's to and from the most direct route, by the most direct route. And you have to inform the company you're about to go. You go to work as well, and you are clear for work purposes 6 a.m. to 10 p.m. So that ought to give you, and you obviously cannot have any contact with the complainant in this case. That would be a catastrophic mess. What would happen is your bond would be revoked if we discovered that, and you would not get a bond. You would have to sit that out in jail because of the nature of this case and the importance of making sure that the victim is not subject to any more possible harm. Fix this.
Yes, sir.
And I'm going to reset this. When's John coming by? Probably, yeah.
John, but he'll need a couple of weeks.
And we're in 3 weeks, reset for 3 weeks, okay? Get a resetting, so thank you. Yeah, I'm sure. She's got it. Joshua Gidry. Gidry. Come on, Epson. In 25 CR 519, you were Joshua Gidry. And Mr. Dusler is here representing you. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary? Yes, sir. In summary, Mr. Gidry, you probably are intimately aware that this states in an indictment handed up on May 7th of this year, this states that on or about March 7th, 2025 in Jefferson County, Texas, you committed the second-degree felony of assault on a peace officer. Do you understand what you are charged with? Yes, police. Yes. Yes, sir. Okay. And if convicted of a second-degree felony, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? Yes, sir. An agreement has been reached between you, your attorney, and the state that you would be pleading guilty, placed on deferred or unadjudicated probation for up to 10 years and limit fine $500. It means you would not be found guilty so long as you followed the terms and conditions of probation, which are normal and customary for all probationers for the most part. If I follow this agreement, you have no right of appeal of your case. Do you understand? If you touch we can't wait.
It's very sensitive these days.
You touch it anywhere, it closes out. These were the new and improved pads that are less improved and aren't new. Yes. How do you plead to this, sir? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty? Yes, sir. Show you what's marked as State's Exhibit 1 here. Did you sign that? We can have that silence. Did you sign that? Yes, sir. Document that's got to sit with your attorney, or the contents all true and correct? Yes, sir. State's Exhibit 1 tendered into evidence? No objection. Without objection admitted. Among other things, the state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offense. You were given your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true, so help you God, it states. Yes, sir. State's Exhibit 1, made a part of the record for all purposes. Yes. I am going to follow this agreement, if nothing further to add, and find it. Mr. Gidry, you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. Even though there's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, I am instead going to defer any finding of guilt and not find you guilty so long as you follow these terms and conditions of probation. Make sure you do. This will be for a term of 10 years. You do well, it gets shortened to 1/3 of that, 3 1/3. And these terms and conditions of probation are normal and customary for people like me. Although we've added anger management class that you must take as a condition of probation, which is a good thing. It helps you think and control your emotions when you're vulnerable. It's good for everybody, actually, to take. There will be a fine here in the amount of $500. Make sure you follow these terms and conditions of probation. If you fail, your probation could be revoked. You could be then found guilty and sentenced up to 20 years in prison. So there's a lot riding on working this thing out well. Okay. All right. Please see the probation officer. Thank you.
All right, let's stay in Texas, but we'll go say good morning to Judge Boyd.
Yeah. All right, are y'all ready to proceed?
Yes, Your Honor.
All right, who's for the state on this? It's Criminal Trial Division. I can do it, Judge. Thank you. All right, the court is calling 2021 CR 2967. State versus Gloria Marie Carrizales. Can I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Horst Stopart for the defendant, Your Honor.
And are you Gloria Marie Carrizales?
Yes, ma'am.
All right. Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Gloria Marie Carrizales who's placed on community supervision in 2021 CR 2967 for the offense of evading arrest detention with a vehicle on April 28, 2021 for a term of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 5. In Bexar County, Texas, the defendant, Gloria Marie Carrizales, did then and there fail to report to the supervision officer as directed for the months of December, January, February, March 2025 in violation of condition number 5.
How do you plead to that? True or not true?
True.
The state will waive and abandon the remaining violations, Your Honor.
All right, there are other violations?
The state does see a supplement.
All right, so did you review the supplemental motion to revoke community supervision with your attorney?
No, ma'am. I only saw one violation.
Okay. All right, did you review that with your attorney?
Yes, ma'am.
And it appears that the state is only proceeding on the violation that you were aware of. They're waiving any other violations. Do you understand?
Yes.
So the court is not going to consider any other violations, only the violation that you've pled true for if you wish to continue with your plea of true. Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, sentence you to 5 years in prison and up to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There is not, Your Honor. We're going open.
And state, what are you recommending?
The state is recommending you grant the state's motion, revoke probationer, but reform the judgment for 3 years, Your Honor.
All right, defense, what are you requesting?
Judge, we were pleading true. It's kind of a unique situation in this case, Your Honor, with an explanation. I think our first choice would be to just deny the revocation and terminate her unsatisfactorily. If I can give a little background, Judge.
Yeah.
And what I didn't have when we appeared before. When she pled into probation on this case and she was granted probation, she was in Bexar County Jail, but she had a blue warrant. And so after she pled on this case, her parole was revoked. And then she was in continuous custody until I have a document here, and it's just from the TDC, and which it also shows that she was in custody, Your Honor.
Any objection to the court reviewing the document?
None from the state, Your Honor.
All right, you may continue.
And so, Your Honor, in speaking with Ms. Carrizales, she did say that she did meet with the probation officer who came to the Bexar County Jail, but they were kind of perplexed as to the reason why she pledged probation when she had an outstanding blue warrant and parole issues.
Usually there's a plea because they think if they were given probation on this and some sort of help, then maybe parole won't revoke them. Sometimes parole will look at that, not revoke them. Sometimes parole will.
In my conversations with Ms. Carrizales, she stated to me that when she did meet with probation, they had represented to her that if she got revoked, then they would seek to modify the probation to.
And since that you discharge.
And obviously that did not occur, Your Honor, and I don't know the veracity of that situation or not, Your Honor. I don't. But you know, she's presenting herself here to the court right now. She's admitting that, yeah, once she was released from TDC, that she did not report. So it's just a unique situation. I mean, there's a situation in which there's confirmation that she was actually in prison. This is not a situation in which she just absconded and ignored her obligations to the court, Your Honor. There's not
There's, I guess it's about 8 months or so left, for the term of probation, Your Honor. And, I think it's just that she was looking for some little, reprieve from the court so that she could either continue on probation or considered, terminating her unsatisfactorily so that she can go ahead and actually, kind of hit truth and get on with forward with, putting these situations behind her, Your Honor. And I think she also wanted to explain some of the things about the circumstances and also trainings and things that she had received since she was first put on probation, Your Honor.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Gloria Marie Carrizales.
All right, counsel, you may proceed.
Now, you had some things that you wanted to tell the judge about what you've done to change yourself since you were put on probation.
Yes, I did the cognitive thinking. I got 2 trades. I got my license in mechanic. I got my MVAC. I got my GED. And I took every class that I could to change my life. I got full custody of my son. And I just had a setback. I had a job. I was doing everything I was supposed to. I was taking care of my child. I was paying my bills. And I just want to get back to that. He goes back to school on the 18th. And I've already missed so much time with him. So it doesn't matter if it's probation or if it's termination, because I'm going to do it regardless. And that's really all I want to say.
Is there anything else that you wanted to tell the judge about?
And I mean, if it's the 3 years, I did the 3 years, and that's when I changed my life. And right now, being in custody, I'm trying to get to more classes. I'm just trying to do what I can to change my life. And like I said, if it's probation, I'll take it and I'll do it. If it's discharge, I'm gonna do it. It really doesn't matter to me. I just want to get on with my life.
All right, so any questions? I'm sorry, state.
None from the state, thank you.
So you've taken these classes, but what have you learned?
I've learned about my anger. I've learned about the way I was thinking and how I hurt people. And I've taken full responsibility for myself and my actions that I learned. I learned to be productive. And if I would have known that I could have just came here, I would have. And I didn't know that, but I mean, there's no reason why I should be in this situation. There's really no reason why, except that I broke the law and I'm just ready to take responsibility.
Probation? What is your recommendation? Any objection to the court review and the court summary?
None from the state.
No, Your Honor.
But here's my question, where have you been?
Where have I been with my son?
Yeah, because I mean, the thing about it is you were released on probation, according to this, November 17th. I'm sorry, released on parole, November 17th, 2024. And after that release, people have been trying to contact you. And what I can tell you is, I remember first starting out, probation wouldn't do all of this.
The person that I was on the probation at, I left that situation, and he's in custody right now for shooting me for leaving. So he wasn't telling me anything.
All right, and who is this person?
James Oviedo. I have a no contact order with him.
I'm sorry, James who?
Oviedo.
How do you spell the last name?
Oviedo. And he wasn't letting me know that probation was contacting me. Nothing. He didn't let me know anything.
And when did this shooting occur?
It occurred a month ago, or like a month and a half ago. I went to go talk to him and get the rest of my stuff. And as I was leaving, he was trying to keep me there. And when I was walking away, he shot me. And I went ahead and went to the hospital.
All right, and what's his date of birth?
It's April 12, 91.
All right, I'm going to think about this for a moment. Just give us a moment. Does anybody want to check into her story with this James Oveda?
The state is confused. Was that the probation officer or like who this gentleman is?
He was the one that I was on probation at his house.
That is the residence where you were staying. So your probation had to, he's not your probation officer. This was a suitor?
Yes.
And I guess probation was going there.
Okay. Just have a seat. We're going to unpack these bags, okay? Just give us a moment. Just have a seat. All right, James Toshi. Your client, Alexandra Dean, is on Zoom.
Okay. Would you like me to?
Yes.
Okay.
Yes. All right, Miss Dean, you need to show your video. Hi, and you need to unmute.
Hello.
Hello, thank you for dressing appropriately on such a short notice. I really do appreciate it.
I tried.
So on this case, where are we on discovery?
Judge, I believe this is our initial setting. I admittedly, I think I have most of the discovery, but I can't tell you that I have it all. I have been conferring with Mr. Garyhan this morning about potential resolutions to the case. And so Ms. Dean not being here, what I would ask the court, if you could allow me to come back in about 30 days to continue my discussions and then make sure I do have all the discovery.
All right, Ms. Ferguson, I need a 30-day reset for discovery, please.
December the 9th, I am in Kendall County that day. Did we do the 10th? Is that
no?
The 11th is a good day.
11th. All right, September 11th, and you'll need to be in court. It's at 9 a.m. All right, you may sign off unless there's any other questions, Ms. Dean.
No, I appreciate it. Thank you so much.
All right, thank you. Have a good rest of your day.
You too.
Okay, let's switch it up. We'll go to Louisiana for our friends at the Board of Pardon and Parole. There's a very good chance that we're going to talk about such matters this evening on Sidebar, so be sure to join us for that, 8 p.m. Eastern, 5 p.m. Pacific, right here on this channel.
You hear us?
Okay, I can hear you. This is the Louisiana Committee on Parole. Serving on the panel today, to my left is Ms. Stapleton, to my right is Mr. Prater. I'm Ms. LeDoux. We are hearing someone at Jefferson Parish Correctional Center. Would the offender please introduce yourself with your name and your DOC number?
Wayne James, 721-360.
Mr. James, do you have in front of you a piece of paper that indicates it's a parole questionnaire?
Yes, ma'am.
Okay, the answers to that questionnaire indicate that you are not eligible for appointed counsel. Do you have an attorney that you hired?
No, ma'am.
Okay. So we'll proceed. Mr. James, you're here because you have violated 2 conditions of your parole. And I'm going to ask Ms. Stapleton to read those out to you. And get some information from you. We do have two people online who will be speaking in your support. And Ms. Stapleton, if you'll call on them at the appropriate time.
Okay. You ready? Okay, so we have the rule violation is number 4. You were arrested on 5/14/25 by the Jefferson Parish Sheriff's Office and charged on a warrant issued on August 2024 for felony domestic abuse, child with the presence of a child under the age of 13 presence. Guilty or not guilty?
Not guilty.
Okay, and it does state that the DA refused the charges. And then number 10, you failed to make a payment towards supervision fees, and you're currently $756 in arrears.
I'm guilty to that one.
Okay. Okay, we're gonna listen to the Collins first to support. Okay, we've got Michelle James on Zoom, your mother that would like to speak.
Are they on Zoom with us?
Okay, we're trying to get things ready for that. Yeah. All right. That's you. Okay. Ms. James?
Yes, hello, how you doing?
Fine.
Can my son hear me?
Yeah, I can hear you.
Hey,
What's
baby,
up, Mom?
I love
Hey.
you so much.
I love you too.
Ma'am,
How you
you
doing?
talk to us. You're here to statement about your son. I know you're happy to see him, but let's.
Yes. Okay, yes, I'm calling on his behalf. My son is such a good boy. That day, whatever happened, it was just a misunderstanding. They have so many people came to the house for his job, dealing with his work. You know, he had a good job. He was at Coca-Cola. He cuts grass. He helped me. I had about a year ago, I caught a stroke. So he really helps me at home because I just lost his siblings, one of his brothers and one of his sisters. So he helps me, and I'm here by myself. And my son, he is so mean. He is such a good child. He works 2 jobs. I really didn't understand that day, but he haven't been getting into trouble. All he do is go to work, come home, and you know he's very concerned about me. But I'm making it. I'm doing it because he makes sure I'm straight. Some guy came here last week, as a matter of fact, for him to help him with his grass cutting. He do that too, also outside of his Coca-Cola and stuff jobs. I have no problem at all. I know I miss my son. I really, want him home. I just give him a warning or something. I don't know. I'm just so happy to see him, but I would rather see him here. I don't want to lose my son into the system, all kind of ways. And, there's evil people inside that jail cell, that provokes him. You know what I'm saying? He might have an anger management problem. Okay, he could go to class, but it's not like that in jail. I don't want nobody to do anything to my son, to hurt my son. I want him to come home.
Okay, ma'am, thank you for your comments. We're gonna go down to Markeisha Griffin. Markeisha.
Good morning. Good morning.
Hello. Good morning. What do you have to say, Markeisha?
Well, that day that we had an incident, it was just a lot of emotions running high. We both wanted what was best, what we thought was best for the child that particular day. So it was just a misunderstanding that kind of went too far. We haven't had any problems. That was our first incident. We haven't had any problems prior to that or after that. He's an active father in his kid's life. So it was just that particular day, it was just a lot of emotions running high. And instead of taking a moment, everybody just kind of overreacted and it made everything escalate worse than what it should have been.
Let me ask you this. The police was called out there. Who called
Yes,
the police?
ma'am. I believe it was the neighbor that called the police.
Okay, and they said they'd been out there earlier.
Yeah, they had came earlier because we was outside. And I guess someone rode by and called the police. We was outside having a discussion. And then we moved, cause like the apartment say we have like a gate. Once we moved in the gate, someone else had called again.
Okay, well, it must have been more than a discussion for somebody to be concerned and call the police. All
It
right,
was
and
a
I
very
see,
heated discussion. It was very heated. We was loud.
well, I see where you could recant it to the DA's office. And in your recant, you said he tried to hurt me, but it was really the apartment door that was messed up. But then you said he tried to hurt me.
I said what?
You have in your statement that tried to hurt you. You also say emotions were running high and everything, and there were problems. But he did try to hurt you, and the apartment door was messed up.
Yeah, she asked me if I felt like I was going to be hurt. I told her that the door was the only thing that got hurt that night. The door was messed up.
Okay, well, anything else you'd like to say?
No, ma'am.
All right, well, thank you very much. Mr. James?
Yes, ma'am.
Okay, on number 4, I've got the police report here. And it says that they were there earlier and that there was 2 separate occasions that on one occasion you began kicking the door on the apartment to try to make entry into the apartment. And that she said that she was going to kill, that if you call, you said that call him, I don't care, I will kill you. And then you fled the location into an unknown direction. And that was earlier that day. What do you have to say about that?
I never said none of that, and I never really kicked the door or whatever. It was just really an argument, and her neighbors called, but I never kicked the door, created no criminal damage, and we really were just into it, but behind my daughter or whatever. Like I'm new to being a father, so I'm really getting the hang of being a father. So, like this, like really my first incident I ever had with my child's mother. So it was really like a lot of the information was really falsified. I think it was like emotions got the best of us, So they kind of falsified a lot of information, but I never really kicked the door. Never really did none of that. It really was just a big argument between me and my child's mother.
Okay, so then there was a second time they're called out.
Yeah, it really was the same. Like they it's like how y'all explained it, like it was 2 different incidents, but it really was just one big argument. Like we started outside, then we started arguing inside the gate. But it was 2 different people called. The first argument we was outside, so I think a car passed and seen us. I kind of saw when a car passed and the lady stopped and looked and said something, so I kind of know that person called the police. Then we start arguing inside the gate, but it really was just one big argument. It wasn't like 2 different separate arguments. It was the same argument, just 2 different calls. Like I guess they called again because we were still arguing, but me and my child's mother never really got into it like that. Only that day, we never got into it after and then like that.
Okay, well, it has a police report that Markeisha suffered a minor abrasion on the right side of her chest, but refused medical treatment.
Yeah, and then again, I don't really know nothing about none of that because I never really put my hands on her. It was a lot of a lot of the information was falsified. I don't know why, but I guess it was like emotions or whatever. But I never really like I've been home like a whole year on parole. I never got in trouble. I never did anything to get myself in trouble. Just the first incident, and the charges have been refused. You know, like I don't really be in trouble and that like that. I really just work. And this was just an incident where me and my child's mother got into an argument. Like,
Yes, please do.
You were paroled May of 24
yes, ma'am.
and you were detained in August.
Oh no. The charge happened in August. Like I stayed home a full year. Like I came home May 2024 and I didn't go to jail until May 2025. This happened in August, but I didn't go to jail in August. Like
Okay.
I actually didn't even know the police was getting called. Like I left and went to work. I just happened to get pulled over leaving work, leaving my job, Coca-Cola, and then when they pulled me over, they ran my name and told me that I had a warrant for domestic violence. But I never even knew the police got called on me.
Okay, I had a wrong date there. Thank you.
Like I've been home like a whole year before.
Okay, well, let's go to number 10. You failed to make payments toward supervision fees, and you're currently $768 in arrears, and you said you were working at Coca-Cola.
Yeah.
So how did that happen?
Okay, like all right, I came home in May, so I just landed my Coca-Cola job. I only been working at Coca-Cola for like I'm gonna say 4 or 5 months. Like I ran through a lot of jobs. Like for me to land that good job at Coca-Cola, like I ran through like 6 jobs because no jobs was paying me enough. And I'm fresh home from jail and I live with my mother and I got 2 kids, so I'm new to being a father. So I really was like trying to get myself together as a man, and really like I kind of forgot about the payments. I didn't really forget about them, but I was trying to just pay one big lump sum of money. I had so much stuff on my plate, so I really couldn't really act up upon the payments. But I can catch up with those payments. Like if I was to be released, like just $700, I can probably catch back up with that within like 2 or 3 weeks. But I really had a lot on my plate because I came home to 2 kids. Before I went to jail, I didn't have no kids.
Be a lot of that could say something like that. Does anybody have any other questions?
Yes, ma'am. I do.
Okay.
Earlier in the day, the law enforcement was called to the residence in question, and you gave them a false name and tried to hide your ID. On the trunk.
I don't recall that.
Do what?
I don't recall that, sir.
You don't have to. It's in the police report. The name that you gave and the fact that you hid your ID in the trunk of a neighbor's car, or you attempted to. What's the deal with that?
I don't recall it. I don't know if that's part of a falsified police report, but I wasn't charged with that charge. I only was charged with domestic violence.
It doesn't matter what you were charged with to me. It matters if you're engaged in unlawful conduct.
Oh yes, sir. I understand what you're saying, but I feel like that's that's part of the falsified. I think that's falsified, sir. Like I don't recall doing that.
Okay. All right. That's all.
Okay, well, I'll read the same thing. You provided deputies with a false ID. And it's in the police report. They also said that they saw minor abrasions on the right side of her chest, but she refused medical treatment. They'd been out there twice that day. So that's all part of the police report, which is an affidavit. Are we ready to vote?
Yeah.
Let me ask one question. You're a 3rd class offender. Is that correct? This is your 3rd felony offense?
Yeah. This charge has been refused.
I know, but you were a 3rd felony offender.
Oh yes, ma'am. Yes, ma'am.
Been on supervision previously?
You talking about the year that I was home before getting arrested?
Have you been on supervision before? Probation or supervision?
I don't think I recall. Like I think every time I went to jail, I kind of went to DOC. Like,
Okay, thank you. We're prepared.
Okay, my vote today, well, y'all had a heated argument to the point that other people called law enforcement. So they must have been frightened for the safety of the mother and the child. So that's in the police report, and then Markeisha said that's exactly what happened, and you did too. So I'm going to revoke you today, and this is my reason. As to condition number 4, probable cause was found based upon the fact of the arrest report and the observations by the police officer that corroborated the initial statements made by the victim. As to condition number 10, probable cause was found due to the subject's admission to not making payments, and Cajun printout showing no payment was made in the arrears of $756.
Mr. Prater.
I concur.
My vote is to revoke, but I hope you get some anger management help while you're in prison, okay? Today your parole has been revoked. That concludes our business there at Jefferson. It's 9/11.
Denied.
A big thank you, as always, to our friend Michael Groff for those wonderful approved and denied stingers that we use here. Again, I'm pretty sure we're going to be discussing the parole board and some of the things that they do tonight on Sidebar, 8 p.m. Eastern, 5 p.m. Pacific, unless something better comes along that demands our attention. Pretty sure that's where we're going to go. Let's go back to Judge Boyd, because that young lady from earlier is back.
Okay.
I nudged her forward a little bit because she was muted.
Judge, if I could do that, I guess it's just from what I'm observing, it's that has a number of struggles, and she continues to, now that she is a victim or alleged victim in an aggravated assault case, it just continues that these problems that she has had to try to overcome and endure, Your Honor. And I think in speaking with her, Your Honor, that when she was in TDC, that she tried to utilize to maximize the time to try to improve herself.
All right, let me ask you this, because it says in the court summary that she was in felony drug court. So did she successfully complete felony drug court? I don't think so. That's why she's here.
I was in drug court when I was in my, I think 18, 19. I wasn't ready to change. I didn't,
Oh, I see that's from 2010. That's before you were placed on probation.
I was about to say, Your Honor, I didn't inquire about that because I saw that in the probation report, but it is from 2010, so.
All right, this is what the court is going to do. The court would deny the motion. And continue her on probation. There's to be alternate men conditions. The following: no driving without a valid license and insurance being presented to probation. There's going to be field visits 1 time per month until further notice. 100 hours of community service restitution. I'm going to order parenting classes. Previous conditions of employment, and I'm going to ask for employment within 30 days of release. No employment as a home health care provider or with minors. There'll be random UAs, TAP evaluation, out of custody, follow recommendations. And then, of course, the regular reporting by Zoom or in person. And defensive driving course. Probation, is there anything else?
Conditions indicate she needed an admission interlock. How long are you giving her to get the admission interlock?
I'm on the bus. I'm gonna be taking the bus.
I was about to say, I don't.
All right, so it's gonna be ignition interlock or a portable monitoring device within 30 days of release. And she can only have the portable alcohol monitoring device if she provides an affidavit of non-driving and no other vehicles at the residence. All right, is there anything else, probation?
Okay.
Is there anything else you need from the court to be successful?
How do I get the affidavit for the?
Oh, your attorney will speak to you concerning that.
Okay, and one more thing, because I do got full custody of my son, I was trying to work towards getting my own place. How do I do the pay it forward?
Oh, probation will speak to you about that.
Okay.
Yes. All right. All right, good luck to you.
Thank you, Your Honor.
You're welcome.
Okay, let's continue in Texas, but we'll go back to Judge Stevens.
Are you Laban Godla? And in 24 CR 1314, you were charged, and by the way, Mr. Grove was your attorney, correct?
Yes, sir.
You were charged here with a second-degree felony of aggravated assault, and that carries with it, if convicted, up to 20 years in prison. Very serious. Okay. What are we going to do today?
Judge, we're gonna ask for some more time, trying to obtain some records, and a person that works for CPS, we've not been able to locate this person yet, or the records that she has. But I think we should do so. We could have a couple of weeks.
Two,
yes.
Okay, you said 2 weeks. Resetting things. Braden Hensley. 24 CR 515. Mr. Hensley here with Mr. Grove, and you know you're charged with this third-degree felony of, well, it's not a good charge. Yes, it's got to be a source of embarrassment for anybody. But deal with pornography. So today announcement.
We could have a couple of weeks, Judge.
It's too good. Two, is that what you're asking?
I'm sorry, Judge, the plan before.
2 weeks. Reset. 2 weeks reset on this one too?
Yes, sir.
Is that right? All right, get a reset, sir. Here, Mr. Hensley, right there. Yes. Katricia Johnson. Katricia Johnson, please. Okay, this is. All right, you're charged with a state jail felony of abandonment or endangering a child here, which carries with it up to 2 years in the state jail if convicted. Serious, and it's a felony. Well, Mr. Grove is your attorney today. Announcement.
You have 2 weeks on that one also.
The 2 week day today, huh?
Well, I'm
2 weeks.
trying to get things in for the end of the month.
Okay. Get reset for 2 weeks, please. Please get a resetting, man. We'll see you back in 2 weeks. Akaya Lane, I think I'm pronouncing this correctly. ACAIA.
She's from there.
Hi, Lane. How do you pronounce your first name?
Okay.
Akaya? You have been for the third degree felony of credit or debit card abuse of an elderly person, which carries with it up to 10 years in prison if convicted. So that's serious. Mr. Grove is your attorney today. Announcement.
Yes, sir.
2 weeks.
Yes, sir.
Okay. He's going to try to get more information and help you on this. We're going to reset this for 2 weeks, man. For 2 weeks, please get a resetting from that lady. Thank you. Carson Moore. Carson Moore, please.
I have to work it out on sheet of paper.
25 CR 497. You're Carson Moore.
Yes, sir.
And Mr. Grove also is your attorney here.
Sorry, guys.
That's okay. But thank God. What is Rick?
Right.
All right, this is an announcement here. You've been charged with second degree felony of assault on a peace officer here. And criminal, what is your criminal history, Annie? You need to fix it. This is fixable. Just don't do something like that again, you know? Yeah, but anyway. Yeah, you need video footage. Okay. We can all use video footage, but your attorney's going to take care of that for you. If there is any. But anything, what do you do?
I would say too, you should
All right.
be able to obtain by then.
Okay. Mr. Boyd, you're on this one?
Yes, Your Honor.
You're going to be able to get any video that might be available?
Yes, Your Honor. We're always ready to go that.
Okay. Get a resetting for 2 weeks, man. This lady, thank you. Arlena Solomon, please. 24 CR 1361.
What's your problem, ma'am?
And Ms. Solomon, as you know, I think we talked about this last time, you were charged with the second degree felony of aggravated assault, which carries with it up to 20 years in prison if convicted. Mr. Grove is helping you. If your attorney today, what is our plan? We have the two week rule.
2 weeks, yeah.
The 2 week rule.
Please.
Okay.
Get the information by then.
Reset here. Get a resetting, please. Jackie Williams. I think I'm pronouncing this right. Two cases. That you?
Yes, ma'am.
All right, Mr. Williams, you probably know this, that you were charged in two cases, 25 CR 151 of the state jail felony of attempting to take a weapon from a peace officer. That carries with it up to 2 years in prison in a state jail felony. It's a state jail felony, a state jail facility. And then 25 CR 152, you're charged with the second degree felony of assault on a peace officer, which carries with it up to 20 years in prison. It looks like this was out of the same event.
Yes.
All right. Mr. Grove is your attorney here.
Yes, sir.
What's our plan today? Let me guess. 2 weeks?
Yes, sir. Court would allow that.
All right, 2 weeks. Reset this 2 weeks. Thank you. Get a resetting. Thank you.
Yeah.
All right, Brittany Holmes, you're up on Joseph Davis. Thanks, David, for getting those taken care of, whatever you can do. Mr. Davis
Yes, sir. Please.
is here. Ms. Holmes is your attorney. Today, what's our master plan?
Rick is spoken as a new prosecutor, so
The new prosecutor?
well familiarized with the case.
New would not have been My adjective might have
Yes,
used.
sir. If we could get a few weeks, I think we'll be able to get these schools.
Yeah, it's like October of last year. It looks like it was invited.
Yes, sir.
So how much time do you think? 3 weeks? That's very good. Okay. Get it resetting, sir.
Thank you.
Thank you. Mariana De Hoyos. That's Mr. Jeffries. There you go. Looks like that's the only one with her. Yeah, you got some other ones from. Correct.
Yes.
Okay, there's an announcement today here on this one, 24 CR 2104. You were Mrs. De Hoyos? Okay, you're charged with a third-degree felony of engaging in organized criminal activity, which carries with it up to 10 years in prison. Serious. Today, what are you going to do?
I've been, excuse me, been communicating with Mr. Ham recently, kicking around a few ideas. We just need probably a few more weeks to sort out.
2 or 3?
3 is possibly.
4 or 5?
5 possibly.
No, what do you ask? Really? What do you?
3 should be.
Is 3 good? Okay. Oh, please get a resetting, man. Thank you. Follow your attorney's advice. We got some smart lawyers in the room today. Dustin Russell. Dustin Russell, 24 CR 385.
It's a plea, Your Honor. I don't know if you have paperwork yet.
I don't.
Oh, he needs to come swear and fingerprint in front of me before I can.
Yeah, there's a formality we got to go through.
The paperwork. There's that.
And I'm going to look ahead because this one's a cluster. The next one is Alberto Zambrano. We call this a gaggle of cases.
That's a fair.
Look at the 8. You. And then we've got another gaggle with Tom.
Yes, yes.
Later here in a minute.
Mine's not a gaggle, Judge.
Yours isn't a gaggle. Yours is more of a giggle.
I agree.
Place it black there.
Can't believe they even filed it.
Can you get up one more time?
Hey, I laughed on that one.
That's all right.
That was pretty good. Mike's not flat.
Judge will call you soon.
Alan had a funny joke. No, it was pretty good. It's all about you.
Good. You know, Russell back up for you.
Dustin. Okay, 24 CR 385 is called the State of Texas versus Dustin Russell. That's you, sir?
Yes, sir.
And present with Mr. Jeffries, your attorney and the state's attorney does. The defendant waive a formal reading of the indictment and the arraignment here. Can we proceed in summary?
Again.
In summary, this indictment alleges that on or about October 16th, 2023 in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand, sir, what you were charged with?
Yes, sir.
If convicted, this is a third-degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached between your attorney and the state. Where? That page. Where you would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for up to 10 years. And there's no fine here, it looks like. Is that there would be terms and conditions of probation, which are normal and customary. You do well on it, you get reduced, it gets terminated in a third of the time, which would be 3 1/3. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand? You can't get rid of these pads fast enough. I mean, if you just I'm left-handed, so I have to touch, I write. That's the way we learned in school in those days. It's just fine. And you touch it and then it just smudges and. Yep. We never had pass on that before, but these were the new and improving ones. But they're very sensitive. Again, how do you plead to this, guilty or not guilty?
Guilty.
Are you and your attorney both pleading guilty on this voluntarily? And I know, not to make light of it, but you would look for him for advice on that.
Yes.
But are you pleading guilty voluntarily and upon discussions with your attorney? Okay, then. I'm going to show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily, understand it, discuss it with your attorney? Are the contents all true and correct? State's Exhibit 1 is tendered into evidence.
No objection.
And without objection admitted. This states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I'm going to follow this agreement, sir, and find you are guilty voluntarily, knowingly, intelligently. You are mentally competent to do so. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 here, admitted to find you guilty beyond a reasonable doubt of this offense. I now find you guilty beyond a reasonable doubt of this third-degree felony of evading arrest or detention with a motor vehicle. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. However, that confinement will be suspended and you are placed on regular probation, what we call regular probation, for 10 years. And there will be terms and conditions of probation which are normal and customary for this. One of the conditions of probation, you must complete a defensive driving class. And that's a win-win, really, because your insurance will be reduced a pretty good amount by completion of that. And other terms and conditions which are normal and customary for this. And the probation office is going to go over them with you in just a minute. Sign this. Make sure you follow them. If you fail, we don't like to talk about it, but if you do fail, you can be sentenced up to 10 years in prison. We don't want that. You don't want it. So fix it. It's fixable.
Yes,
just do what you're capable of doing and you'll be fine. Okay. Yes, sir. Thank you. Yes, sir. Alan Parker.
I gotta say, Judge Stevens can sometimes be gruff, but I appreciate the fact that he always has a little bit of encouragement at the end, telling people that they can fix it and they can make it right. I just personally appreciate that. Let's stop bouncing around the South and go up to Michigan for a minute and back to Judge Dad.
Need to come here at 8. We don't even open the doors till.
I wasn't sure what time you guys open or not.
Yeah, I don't have a problem. Your name?
Timothy Money.
All right, so he pled guilty to operating while impaired. The OWI was dismissed. He was referred for screening and assessment. Have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
Good morning, Nancy Gate, appearing behalf of Mr. Arnold. I've had a chance to review the pre-sentence report, Mr. Arnold. No material changes, corrections, or additions, or deletions.
Was the other driver still on scene when the officer came aboard? Came on scene?
I honestly can't recollect.
You didn't really have a cat run out in front of you, did you?
No.
You just told the police officer that? Was it a one vehicle accident? I know it was a dirt bike.
It was a mini bike, Judge.
Yeah, I'm sorry, mini bike.
Collided.
Pardon?
Me and my friend collided. I was on one and he was on another one.
Is he okay?
Yeah.
You were okay?
Yeah. Besides a headache, it took about 2 weeks to go away.
All right, what else? Anything else?
Just that Mr. Audi is 31 years old. He just actually started his job today. He works at the Family Dollar, right across the street from the courthouse.
Okay,
Judge, he has no significant criminal history other than there was out of the 25th District Court back in March, which is, he had a warrant issued and he didn't know about that until we actually informed him about it the last time he was here. He's in the process of taking care of that. Judge, Mr. Audi doesn't really get in trouble. This was a situation where his friend had purchased these mini bikes. They had a little too much to drink and they were just driving and got into an accident between both of them. No one was hurt, and I just chalk this up to carelessness at this point.
I made a mistake that I won't ever do again. I've always tried to stay out of trouble because my mother was a disabled American veteran. I didn't have a father growing up, so she was kind of both a mom and a dad. She passed away a few years ago, and that's when I really started drinking randomly, to tell you the truth. Before then, I didn't really like drinking. The only thing I can say is I made a mistake, and I promise I won't ever do it again.
okay, good enough. 6 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You change your address, place of employment, or home telephone number, you have to notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs.
I haven't done
Hang on.
anything.
Kratom, poppy seeds, and CBD oils are prohibited. If you consume food or other items containing those substances, that will be deemed a violation. I'm in order that you attend the educational level 2 alcohol education program with the Victims Impact Panel. I won't order court work. 3 days jail, credit 1, serve 2. I'll let you serve those by way of community service. 2 days community service, that's to be completed by September the 20th. So you got about 6 weeks or so to complete your 16 hours of community service. 300 fines, 225 costs, 75 victims' rights fee, $50 justice assessment. So fines and costs here are $650, screening fees $60 for 710, probation fees are $120 for 830, cost of recovery is $150, your total is $1,080. You may be eligible for early discharge if you're compliant, get everything done, and in 3 months you could apply for early discharge. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. At least you're showing some humility. I do want you to clear all your outstanding warrants, though.
No, I understand.
Clear all outstanding warrants by September 20th as well. You understand?
Yes, Your Honor.
Okay.
Judge, Mr. Audi is going to get payment.
How much does he have today?
He doesn't
Anything?
have anything today. He just started his job.
It's fine. Can you pay $50 a week, you think, or no?
Yes, sir.
You pay, are you sure?
Yes.
$50 weekly. I'll start that beginning on September the 5th. If you don't have the money at any time, you call the court. We'll go on Zoom. I'll give you an extension, or you can walk in here on or before the due date. I'll be glad to give you an extension, okay? Good luck to you. You'll meet with probation. If you want to tell them that I said it's okay if you schedule again to come back, if you got to get to work, no problem, okay?
Can I get a copy of the paperwork?
Yes, they're going to give it to you when they instruct you,
Mr. Audi, just go across.
okay?
Thank you.
Good luck to you. Is Kelly Ferguson here?
Yes.
Kelly Ann Ferguson, 2OR-511-787. Kelly Ann Ferguson, 219R-511-211. Good morning. Your name?
Kelly Ferguson.
Good morning, Judge. Mason Gate, on behalf of Ms. Ferguson, is the concept.
Let's talk about the assault case. You pled no contest back on June 26th. You were in the hospital. We adjourned the sentence, etc. There's an issue with the printing.
There was an issue with the printing, Judge. I believe Detective Mercure was here the last time, and he did advise that Miss Ferguson had gone into the station to get printed, but they did tell her that her prints were already on file.
The point is, did she go back and did we resolve that? Has that issue been resolved, or I still need her to, well, there is one here. Hang on one second.
I believe they do have.
It's July 14th of 20. Let me check something here.
Judge, she's just like Mr. Hamadi. She needed to get reprinted, but her phone number doesn't work. So I mailed her a letter, but she didn't do it.
Where do you live?
Church Street, Marble.
I need you to get printed. I need you to get printed. Did I cover this in front of Detective Mercure
Yes,
last?
sir. This is the third time Miss Ferguson's been before.
I know, but did we not tell her to go get printed? Did I not tell you to go get printed last time?
No.
I don't recall.
Well, I don't see how this is,
Judge, at the last hearing, we were unsure what happened. So I looked into it, realized both of them had to get reprinted, but I could not get a hold of Miss Ferguson. So I had to mail her a letter.
right, okay. I don't have a problem with sentencing her now. But part of the sentence is going to be that she has to get printed on the assault charge. She pled no contest to assault back on June the 26th. I did not order a pre-sentence report on that charge. So what do you have here, counsel? What do you want to do?
Judge, I've reviewed the pre-sentence report with Ms. Ferguson.
Now, remember, there was only one on the child endangerment that was 19R511211.
Correct. Judge, with the assault case, I believe that was the case that was is that the 2019, or sorry, that's the 2020 case, correct, Judge?
Correct.
The reason she pled no contest to that, first it was, was 5 years old. Additionally, at the time, I believe she was just getting through some surgical procedures, and she was on medication that maybe hindered her ability to correctly recall the events of what happened that day.
Okay, that's fair. That give me 1 second. I just need to check one thing here. If you can give me a second. You know, I don't even know who they're listing as the victim here. They have both the officer and a Quinn Parker. I mean, it's just a strangely written report, or at least I can't add everything up. They say she was arrested for assault on both, and they only charge 1 count of assault, and they don't indicate who it is. I believe it was Mr. Parker, though. Is she still seeing Mr. Parker?
Yes.
What's your relationship with Mr. Parker now?
We live together. We have 2 kids together.
All right, what else would you like to say, counsel? I can handle both of these at the same time. The one's got a child walking around. You got to get your, like,
If I may, Judge, not to cut you off, that issue, according to Ms. Ferguson, that was the time she had bladder reconstruction surgery.
she was intact, she was under the influence.
Not at that time, Judge, no, she was actually under the influence of medication. She had just finished surgery for bladder reconstruction. She was under the assumption that her partner was gonna be at the residence. He ended up leaving and going to work. She was in bed recovering. Next thing she knew, the officers had woken her up and told her that her child had gotten out. But she was under no, she didn't know prior to that her partner was gonna leave. She thought he was gonna be there to care for the
It
child.
appeared the reporting officer Ferguson was under the influence of some type of narcotics. Trash and numerous toys were scattered around the floor of the home. Dirty dinner plates on the table with food scrapes and flies on them. Curdled milk, foul odor in the home. She said, "Don't tell me he went out the front door again." Again, he reiterated Ferguson was under the influence of some type of narcotics. No food in the refrigerator.
Again, she was in the process of, she had some number of medical issues and she was being treated for that. She had just gotten out of surgery.
Where was the father at? Where was Mr. Parker?
He went to work. He wasn't supposed to go to work. I just came home from the hospital the day before. I was in the hospital for a month with the surgery. I was on Tramadol. That was the only medication I was on for pain relief that I was prescribed from the hospital.
The 2022 case, possession of narcotics out of the 24th District Court. What kind of drug was that?
What district?
24th District Court, Allen Park.
That was cocaine.
Okay. And you got a warrant out for possession of drug paraphernalia out of the 16th in Livonia.
Yes, I was.
Ms. Ferguson, if you're gonna have children, and you have them, you need to take care of them.
No.
You need to make sure that children cannot get out the front door, and that child was how old again at that time?
It was almost 3.
All right. You cannot allow your children out. CPS was involved, everybody else was involved. Do you have a mother or father in the area?
No, I do not.
What else do you want to say, Counsel?
Judge, just that, currently right now, she's not working due to her situation. She's currently also going through a number of medical issues, Judge. Right now, she's not working, but she is in school for cybersecurity. Hopefully she would have, well, at the time the report was written, she would have graduated or finished in, I apologize. She started a program for cybersecurity through Kaplan University, Judge, in July, and she's due to finish in January of next year. She does have 2 minor children, Judge, like you stated. Obviously, she's doing her best with the circumstances that she's got. She has no family around her, so she does depend a lot on her partner. And Judge, just that, she's trying to make good choices and trying to deal with, what she's got going on medically. So we'd ask the court to take that into consideration.
Do you get me?
Yes, Your Honor.
Anything else you want to say?
Just that I'm trying to get my life back together.
Okay,
I know I messed up in the past.
okay. So you gotta do that though. When we bring children into the world, you know who's the best position to raise them appropriately with ethics and values and integrity and everything else? It's not the system, it's the parents. You can't let your child go walking out of the house.
No, they deserve it. They deserve the best.
12 months probation. I'm sentencing you on the child endangerment/neglect first. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to record as directed, no alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, PVTs and ETGs monthly. Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You have to attend a parenting class and provide proof of completion. You're to clear all warrants by September 30th. I'm going to order that is there a reason you can't obtain employment?
I am undergoing for renal cell carcinoma.
Okay, I'm going to delete that requirement. Fines 100, costs 100, 250 in probation, 240 in probation fees, 75 victims' rights fee, $50 justice assessment fee, $60 screening fee. So I'm going to add those up and they're going to come out to $625. I won't even charge you attorney fees. If you violate, your probation could be revoked. You could be incarcerated for 90 days. You may be eligible for early discharge if you get everything done. Do you understand that?
Yes, sir.
Now, on the other file, I'm simply going to say to you, 6 months probation. I won't charge you probation fees. I won't charge you a screening fee. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. $100 fines, $100 costs, 75 victims' rights fee, $50 justice assessment. You have to be printed and photographed by the end of the day. You have to go for your prints by the end of the day. There's to be no assaultive, abusive, or intimidating behavior toward the victim, Quinn Parker, or assaultive, abusive. So Lisa, we're going to lift any no contact provision. I think Judge Heston made it the officer, and I'm fine, but I want to make sure those bond conditions are lifted as it relates to that. I'm also going to order on each one of these cases, and I will run them concurrent, that you serve 3 days of community service. I'm going to give you until October the 20th to complete that. 3 days of community service, 24 hours community service. I'm going to order that on each case, but community service hours concurrent between 2 OR 511787 and 19R 51121. Do you understand that? So you only have to do 24 hours of community service, and that'll satisfy both. Okay?
Okay.
All right, now, so you owe 6 1/4, plus I'm going late on this other one, 3 1/4, or 90 days. I'm going to let probation to set up terms of payment with her. Lisa, we're going to do that on both of these. Probation to set up terms of payment, so you'll meet with them today, and they will set up your payment terms, okay?
Okay.
And if they give you a schedule that you can't fulfill, all you have to do is call the court and come talk to me, or walk in here on or before the due date at 8:30. I'll be more than reasonable with you. Please do not ignore me, okay?
Okay.
You seem like a nice lady. You gotta get your life in order.
I'm trying to.
How old are you now?
34, too old to be.
You got 60 more years ahead of you, presumably. Let's do this. Let's make sure these kids are raised appropriately. Most important thing we do in life is raise kids appropriately. I don't care what anybody says. Everybody talks about money and success and all these other nonsensical, frankly irrelevant things, and then the most important one we tend to forget about. Good luck. I wish you well. I really do. Best of luck.
Thank you.
Willis.
100% agree with Judge on that one. Let's go back to Judge Boyd. She's got a
It's calling 2025 CR 007409. State versus Patrick Keith Thomas. Can I have parties announced?
Jason Gary for the state, Your Honor. James Stothey for Mr. Thomas.
And are you Mr. Thomas?
Yes, ma'am.
Counsel, is there an application?
No, ma'am.
All right. Counsel, have you received all discovery? Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Thomas, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with theft with 2 or more previous convictions as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Mr. Thomas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 180 days in the state jail facility. And there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. State Exhibit number 1 with all of its attachments. Without objections, Judge.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yeah. 130.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We're ready, Judge.
Anything you wish to say on behalf of your client?
No, ma'am, at all. We're obviously just asking the court to honor the agreement.
All right, the court will sentence you to 180 days in the state jail facility, give you credit for any time served, and there's to be no contact with Walmart. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, so we can go off the record. Here's the thing. If you don't stop doing this, you're gonna end up in and out of jail. You understand? And out of prison.
Only thing I can say, Your Honor, is stupid.
Yeah. So
I mean, I don't have an excuse for myself.
Yeah.
It's really stupid.
well, I mean, you have to figure out why you're doing what you're doing and stop it, okay? Because otherwise, it's not gonna end good. And at some point, these state jail felonies, the range of punishment becomes 2 to 20. All right?
Yes, ma'am.
So if it's a homeless issue, there are plenty of places to stay. If it's a compulsion issue, there are plenty of places you can get help. You understand?
Yes, ma'am.
All right, good luck to you, sir.
Thank you.
You're welcome. Who is here on Raymond Francis Haynes?
Morning, Your Honor.
Good morning.
Does Mr. Haynes need to come forward, Your Honor?
Yes.
Hey, Honor. Thank you. Hard to get people up here.
Oh, it is. People don't want to come. But you know, I've discovered during jury trials, people don't want to leave. Jurors want to leave, but then they don't want to leave. All right, where are we on discovery?
Judge, I think discovery is complete.
I believe
discovery is complete. Yeah, that's what I know, Judge.
All right, so I need an acknowledgement of discovery before you leave. And was an offer tendered today?
No, Judge. Defense counsel can explain that. Yeah, not yet, Your Honor. We would like to have Mr. Haynes. He's 100% disabled for veteran, and we would like to have him evaluated for VTC. I guess I'm not. I think that after that, if he's eligible, then we get an offer. But that's. I think that's the route we would like to go down as of now.
All right. Vashawn, do you have any idea how long it would take VTC to review him?
I don't know it. Just give me one moment.
All right, so just have a seat. They're gonna call VTC and see how long this will take, and then I'll give you a date.
Thank you.
You're welcome. Who is here on Robert James Kianis? No, I have Matthew Dotson, Martinez, and Haynes. All right, Mr. Kianis, come up. All right, so in this case, where are we on discovery, count?
I confirm with Duffy, it appears that we have everything. We were just asked for a short recess. We can go through it all and confirm that we're not missing anything. If the court would let us come back in 2 weeks, just so we have time to make sure we aren't missing any additional discovery.
All right, Norma, if I can get a 2-week reset for discovery, please.
Thank you, Barbara, for gifting that membership. Very much appreciated. Congratulations to S for receiving that. That's minimalist naming at its best right there.
Make sure that your attorney has all of the information that the state has. Do you have any questions about anything?
I would just like to raise a timely objection to the Texas being abstract subject matter jurisdiction, and I'm not waiving the right to the defect.
All right, so you're saying subject matter jurisdiction? All right, so usually when you're speaking of subject matter jurisdiction, no, I hear your objection. Usually when you're speaking of subject matter jurisdiction, that's usually on the civil side. So what I can tell you about subject matter jurisdiction in this court, and I think I know what you're trying to say. So you're charged with a felony. So this court presides over felony cases. So based upon your indictment, which is a felony indictment for aggravated assault with a deadly weapon and unlawfully carrying a weapon with a felony conviction, those are all felony offenses under the penal code. So you are in the correct court. So the subject of your indictment is what the type of cases this court handles.
And I'm going to be able to have a trial, right?
If you, I can't give you any advice, but your attorney is here to assist you. And if you want a jury trial, of course, the court will give you a jury trial. But what I usually do in the process in this court is I want to make sure that your attorney has all of the discovery, which means he has everything that the state has. And if he thinks there's something the state doesn't have that he should have, he's entitled to have that. And then once he tells me he has all his discovery, then I will set this for a plea deadline date because I require that the state tender an offer to you. You can discuss that with your attorney. If you decide not to reach an agreement with the state, then the next course will be a jury trial. All right? All right, thank you, sir. Have a good one. All right, so where is he? Come forward, please. All right, can you raise your hand? You solemnly swear and affirm all is true and correct and include your personal knowledge. All right, if you'll fill that out, and then I'll take it up. All right, Larry Morris. All right. Matthew Luis Martinez. Just let me sign this.
We want to sign those two. I don't do it from a district bench, I do it from a justice of the peace.
Hey, it's still needed. All right, thank you. Have a good one. All right, court is calling 2025 CR 0508084 State versus Matthew Luis Martinez. Can I have parties announced?
Ashley Jones for the state.
Tommy Ramirez representing Matthew Martinez, Your Honor, we're present and ready.
All right, and are you Matthew Martinez? I'm gonna need you to speak up so I can hear, okay?
Your Honor.
And the court reporter. Counsel, have you received all of the discovery in this case and did you review it with your client?
I did, Your Honor, in my office.
Court will find that the state is in compliance with discovery. Mr. Martinez, did you review the application for deferred adjudication with your attorney?
Yes, sir.
Did you understand it?
Yeah.
And did you sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney?
Yes.
Did you understand it?
Yes.
Just one moment. Do y'all have the indictment on Martinez?
I actually have an extra copy, Your Honor.
All right, thank you. Thank you. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand you're charged with burglary of a habitation? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able, I'm sorry, is he applying for deferred adjudication as well?
He is, Your Honor.
All right, did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine.
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor, we've been able to discuss it at length.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $1,500 fine. The state is opposed to your application for community supervision and deferred adjudication, and there's to be no contact with the complainant. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor, that is our understanding.
State?
Yes, Your Honor, that is our understanding.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
Not to my knowledge, Your Honor, but I'm not the court-appointed lawyer who was here before me, but my understanding in reviewing the file, there are none.
Thank you. And then, Mr. Martinez, to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
The state would offer State's Exhibit 1 and all attachments.
No objection.
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We can go off the record. So a PSI takes about 8 to 12 weeks. So we can reset this for 8 to 12 weeks for a PSI and TAP evaluation, or if you would like, I can have this recalled back in a shorter time, and you can bring whatever witnesses you want to bring. And I do ask that the state bring the criminal history.
Your Honor, I think we can probably come back sooner with a couple of witnesses. My client has been recently released from a prison sentence on a revoked probation. He has taken steps, has found meaningful employment, which is difficult for a felon. He has already made arrangements with the state of Texas to get his driver's license reinstated and has an appointment for that to be done on August 28th. Once that is done, his employment will become full-time and permanent. He has also made arrangements so that he will not have any contact, and this was before this arrangement today. As soon as he got out, he made arrangements so he would not have contact with the mother of his 2 children, and he has been having his mom be the one that picks up and drops off so that mom doesn't feel threatened in any way. So my client is taking significant steps to try and get that done, and we can present some testimony on that when we come back a little bit sooner.
All right. So then what we will do is, Ms. Ferguson, if I could have a reset date on this for 3 weeks, and if you want to, or do you want it, if you want it sooner, just let us know.
I'd like it, if we can, Your Honor, that first or second week of September. That way he would have already obtained his license by then.
All right, so it can't be the first week in September because I have a judicial conference. So,
The second week.
all right, Ms. Ferguson, what date?
I can do the 8th.
Yeah, Monday works best. I have a docket I have to call on Tuesdays.
All right, thank you. Once you sign the reset form, you are excused.
Thank you, Judge. We appreciate your patience.
All right, thank you.
Okay, friends, this is the logical place to leave it for today. So this is our animal/nature for today, and I haven't had a chance to cut there yet, but it's quite interesting. This is a feed compliments of Furball Farm Cat Sanctuary. They're up in Minnesota, and they specifically bring in ferals. They say they work with professional trappers to get feral cats and bring them in and give them a good home. And I've been watching the feed, and it kind of cycles through all their different cameras. And what's really interesting is how clean and tidy they keep the place. They've had a crew in there all morning long just cleaning this thing from top to bottom. So it's quite the little operation. Again, it's Furball Farm Cat Sanctuary. And it's furballfarmcatsanctuary.com if you want to read up on them. So check them out. It's kind of neat. We'll be back live on this channel this evening, 8 p.m. Eastern, 5 p.m. Pacific for Sidebar. Pretty sure we're going to talk about paroles and pardon hearings and stuff like that. We'll be back tomorrow morning, 10 a.m. Eastern, 7 a.m. Pacific for the normal show, a half an hour earlier for channel members. And a reminder to check out the sponsor for today's show, Aura. That's at aura.com/TCF. There's a link for that in the description of the video. And it is worthwhile. I'm getting reports now from people who have signed up as to the benefit that they're seeing. Did I not say sidebar? What did I say, Bailey? Sidebar tonight. 8 p.m. Eastern, 5 p.m. Pacific. Tune in. We talk. It's fun. Okay. So anyways, yeah, check out the sponsors. Support the company that supports the show and help yourself, because it really is... it's amazing what they'll find for you when it comes to your online data and how janked up it is, how much of it is out there, and what they can do to fix it is great. So anyways, again, we will see you tonight. Oh, Bailey said I did say it right. Well, you made me nervous when you just typed sidebar in the chat. Anyways, we'll see you tonight. This outro is a mess. Take care. God bless.